Good morning. Good morning. Good morning, dear. I think we need to start with the work for today. We are going to be receiving a briefing from the Department of Justice on their budgets and the APPs. And then thereafter, we will also do the same with the Legal Aid South Africa. I will start by welcoming the Deputy Minister, who is leading the delegation from the department and the Director General. DM, can you make your opening remarks? And DJ, you know that we have written to all entities and departments that the presentations we are going to limit the departments and the entities to 30 minutes. Yeah.
Thanks, Chair. Sorry, just trying to get my camera sorted out. But good morning to everybody and to the members of the committee. As you know, this is the presentation of the department. So it's effectively the DG and the department's day. I'm here accompanying them on behalf of the Minister, who unfortunately wasn't able to attend due to other commitments. So yeah, I don't think the Minister made his address to the committee. So there's not much more to be added. I'll also be there to respond to some of the questions, but if I can then hand over to the DG.
Thank you very much, Dia. Director General, Advocate Mashabela, can you start? You have 30 minutes.
Mashabela, Chair.
My apologies.
Honorable Chair, Deputy Minister, honorable members of the Portfolio Committee on Justice and Correctional Services, good morning. I want to take this opportunity and thank you for giving us this opportunity to present the departmental annual performance plan for the financial year 2022-2023. Briefly, before we get to the presentation, Chair, I thought we just need to make some few remarks, just in alignment with what the Minister has already highlighted during his political overview earlier in the week. That last year when we appeared this time and made a presentation on our APP for the year 2021-2022, ours was not just an ordinary APP, but it was accompanied by elements of turnaround, which was expected from us as the senior management of this department, in line with what the priorities of the Minister and the Deputy Minister and their leadership were, and in light of the challenges that the preceding year, had indicated attended to the department in terms of the decline of performance. And in our presentation, we did indicate that there specific issues that we're going to attend to as we implemented the APP that will seek to turn around the situation in the department. I know that the committee preferred us to have a rescue plan, but we came around with a turnaround plan. And I thought briefly I should indicate that those elements that we had identified, which were 8 pillars of the turnaround, we are confident that
DJ, we can't hear you.
DG, you're actually muted. You've muted yourself.
Thanks, Chair. Yeah, the system was muted there. I hope we're back, Chair. You can hear us.
Yes, we can hear you.
So I was saying, from the turnaround plan that we began implementing in the preceding year, 2021-2022, as we concluded the year at the end of March, we have the confidence to tell you as senior management of the department that the situation in the department is being turned around. We the characterization of a regression that was made a year earlier has been arrested, and we're seeing an upward trajectory. And as we come back in 2 months or 3 months to present an annual report, we will be able to present that. However, challenges remain, and in the main, you'll recall that when we presented the annual report last year, we did identify specific challenges that are besetting the department, primarily around our modernization program, the ICT system of the department, which we committed to deal with, and indeed we are dealing with. And in the next 6 months as well, we've committed ourselves to rapidly making sure that we build a foundational and a strong capacity for the department to modernize. As part of that, a political decision has already been taken by the minister that we need to set up a branch that will deal with the ICT and build internal capacity, move away from the historic approach of outsourcing our ICT, because the majority of the challenges that we had came from that lack of capacity. The second major issue, which was even raised during the political overview, related to our facilities management, which is an external dependency in the main, because the Department of Public Works and Infrastructure has the statutory mandate to deal with matters of state facilities. However, we are making a progress through the leadership of the minister and the deputy minister in our dealing with public works, and as we'll continue to deal with the minister, to engage with the senior officials, including the DG of the department, we are hopeful that in the less than 6 months, we'll have made significant progress with the challenges that we have been facing with the state of facilities. And we are aware, of course, that the portfolio committee has seen firsthand some of those challenges. So we hope that with your support as well, and of course, the leadership of the minister and the deputy minister, we'll be able to address this issue around facilities. So I thought those are the issues that we needed to reflect as the main issues that continue to have challenges on us. And finally, on capacity, you'll recall when we appeared last year, the department for a year did not have a chief financial officer. Now, we manage a big budget, and it was not because of any incompetence or a failure on anyone that we didn't have a CFO, but because of the processes that were unfolding. I'm happy to announce that Cabinet has finally appointed a chief financial officer. We started on the 1st of April, and we're very hopeful that even the matters that related to how we manage contracts, with some of it related to the issue that was raised on Monday on court recording technology, which was a pure procurement and contract management issue. Those issues will be addressed because the branch finance has now been capacitated. The senior vacancies that were there, chief directors and directors level, have now been filled, with the exception of one that we are in the process of filling, and in the next 3 months, we'll have a chief director supply chain. So I thought, Chair, that's very important that I do make that reflection to say that we're not just presenting an APP, but we're presenting an APP mindful of the state of the department as it was a year ago, and positively saying we are turning the corner. And the next 6 months and the next 12 months of the implementation of this APP we're presenting here, we're convinced that we'll completely turn the corner. Yesterday, the minister launched the Year of the Community in Mpumalanga, which is part of what we'll be presenting here in our APP, which is a commitment for the department to reach out to the community, to engage the community around the 25th anniversary of the Constitution on matters of constitutional democracy, constitutionalism, respect for the rule of law, as well as the promotion of human rights. But equally, engaging communities about the services of the department across the board, all the services from the masters and the court services that we need the members of the community to know about the services, and also give them an opportunity to give us a feedback. Chairperson, with those words, I invite my colleague Terence Rasaroka to take us through the presentation. Thank you.
Thank you, DG. Good morning, Deputy Minister, Honorable Chairman, and Honorable members of the committee. I will be presenting the departmental APP for the current financial year. I need to indicate that these plans were developed in 2 planning sessions that were held in the last financial year. So the first and the second draft were submitted to the relevant stakeholders, and our APPs are aimed at contributing to the 2030 national development goals of strengthening the criminal justice system, as well as the priorities of the current sixth administration, particularly the social cohesion and safer communities, and the midterm strategic framework priorities. We are also we ensured that our APPs are aligned to the relevant frameworks, as well as indicate that in this financial year, we'll continue to focus on the 10 strategic outcomes and the 77 output indicators. We'll do this, Honorable Chairperson, through the 5 programs that we have as a department. While we present our APPs today, we thought it is important for us to update the committee about the ransom attack that we experienced sometimes last year. This attack had an impact on our IT systems and rendered them inoperable. And it affected the service delivery, our annual performance plans, and our day-to-day operations. Progress on our modernization program was also affected. So in restoring our services, we worked with the state agencies and the industry experts. As we stand today, there's no evidence of data loss or use of department's data in the public domain as a result of this attack. In an effort to prevent the recurrence of this attack, we as a department management went on an ICT retreat in December last year with the aim of wanting to understand how the attack occurred, and we also charted a way forward on how to best protect ourselves in future. We are currently, Honorable Chairperson, protecting our digital assets by doing continuous threat detection and preventing and using the IT security toolsets. We are also improving and implementing our new IT security products, both hard and software, as informed by the continuous security assessments. Now, in terms of our mandate, Honorable Chairperson, our mandate remains the same. In terms of the Constitution, our constitutional mandate is derived from Chapter 8 of the Constitution.
Sorry, sir. Can you skip the mandates? Can you skip those things that we know? We want to know your plans. I doubt that you'll be able to finish within 80 slides within the 27 minutes that the DG gave you, because it took 7 minutes, 23 minutes. So you have less than 20 minutes left now.
No, thank you, Chairperson. I will just move to the slide number 20, which is the slide focusing on measuring our performance. Honorable Chairperson, we will do that, as I said, through our program. So our first program is administration. And in this program, we are focusing on contributing to outcome number 1, which is modernizing and increasing access to justice services. So modernizing the justice services remains our key priority during this planning cycle and for the improvement of the quality and speed of our services. And during this year, we developed the pilot phase 1 of the solutions that will provide the following services: maintenance, trust, expansions, disease first aids, and the NRSO. So the phase 1 enables clients to do online registration and submission of applications. We also developed and tested protection order online services. However, we did not pilot because of the rules and regulations that must be amended before the piloting and implementation. So in the current financial year, we will develop phase 2 of the services, which will include transacting capabilities. We will also commence with phase 1 of the state attorney's online services. We'll roll out courts audio-visual solution in 85 courts in this financial year. And in the next slide, Chairperson, this is how we have broken down our particular outputs. As I said, that if you look at column number 4, those are the outcomes. I mean, those are the targets that we have for the current financial year. I will then move to the next slide, which is focusing on the outcome on improved organizational capability and good governance. That is slide number 25. I Our effort to improve organizational capability, good governance, and audit outcomes in the current financial year will be focusing on reducing regular expenditure by 65%, fruitless and wasteful expenditure by 85%, and will process 98% of all undisputed and valid invoices within 30 days from the date of receipt. In order for us to combat fraud and corruption, which we know that it poses risk in the public service, undermines the rule of law, and impedes government efforts to achieve the socio-economic development and service delivery obligations. In the current financial year, we will investigate and finalize 75% of all incidents of fraud and corruption. We will also investigate and finalize 85% of the reported corruption cases. We will also empower women, youth, and people with disabilities and prioritize them when filling vacant positions. We will maintain 2% appointment of people with disabilities and improve the appointment of women at SMS level to 50% and youth to 22% respectively. So this is demonstrated in the next slide, which is 26. Those are the percentages that we have actually allocated for the current financial year. So the slide 27 is still the same. I'll move to slide 28, which is our contribution to achieving outcome number 3, which is improved awareness of justice services and constitutionalism. In this one, we consolidated all indicators on awareness campaign on justice services and constitutionalism. And in this outcome, we will monitor them as a collaboration between business unit and our communications unit. We will conduct 250 public education and communication activities so as to enhance awareness of the justice services and constitutionalism. We'll have visible anti-xenophobia and 4 trafficking in persons campaigns this year. We will also have LGBTIQ and NIS activities in collaboration with other departments and role players. We'll also host a national conference and organize 150 events to celebrate the 25th anniversary of the Constitution. These indicators are in line with Cabinet approved program to commemorate the 25th anniversary of the Constitution. And we started this in the commemorative of the commemorations last year. So the next slide is also giving us those details in terms of those numbers as outlined on column number 4 of the template. Then I will move to program number 2, Honorable Chairperson, which is our court services. In terms of our program number 2, this program contributes to outcome 4 and 10. And in terms of its contribution to outcome 4, it's all about increased access to justice services. We will continue to implement interventions that addresses the scourge of gender-based violence and femicide against women, children, and the community of the LGBTQ. This year, we're also developing phase 5 of the Femicide Watch. We will establish 8 sexual offences courts at designated courts. We'll finalize 90% of child justice disciplinary inquiries and issue 55% of the NRSO clearance certificate of applications received in the financial year, and finalize the backlog cases of almost 3,000 applications. We will also finalize 80% of litigation and non-litigation family advocate matters. 75% of maintenance matters should be finalized within 90 days from the date of proper service of process, and that 30% of investigations must be finalized within 90 days of receipt of instructions by the maintenance officer or referral by the clerk of the maintenance court. We will also ensure that 27 of our courts are compliant with the strategy on universal access for persons with disabilities, and also ensure that we finalize the discussion document and submit to Cabinet this year for social impact between 3 branches of the states that is intended to foster and strengthen the constitutional relationship between respective arms of the state. So in the next slide, this is just a demonstration of what I was explaining, and we have actually allocated those specific targets on column number 4 of the slides. Now, if we move to slide number 39, which is still program 2, here, this program contributes to outcome number 10, which is crime and corruption reduced through effective prosecution. In this effort, Honorable Chairperson, the fight against fraud and corruption is on our radar over the midterm period. And last financial year, we established 6 specialized commercial crime courts, and this year we will capacitate 2 of those. So the next slide is just giving us that demonstration of what I have just indicated. If we move to slide number 41, it's program number 3, which is state legal services. And this program, Honorable Chairperson, it contributes to outcome number 5 of improving master services. And this year, our plan is to have 85% of liquidation and distribution accounts in bankruptcy matters examined within 15 days, and 85% of letters of appointment in curatorship estates issued within 15 days. Chairperson will also ensure that 80% of beneficiaries in guardian funds receive their payments within 40 days from receipt of all required documents, and 80% certificates of appointment issued in all bankruptcy matters within 10 days from receipt of all required documents. 75% of liquidation and distribution account in large estates will be examined within 21 days from receipt of all required documents. We will also issue 70% of letters of appointment in decreased estate within 21 days from receipt of all required documents, and issue 65% of letters of authority trust within 21 days from receipt of all required documents. We will also, Chairperson, I also think that it's important that we note that as we calculate the number of days by subtracting the date of receipt of application with all required document from the date the matter was finalized, excluding public holidays and weekends. So the next slide clearly demonstrates those indicators and targets in terms of my previous explanation. So if we move to slide number 45, which is program 3 contributing to the achievement of outcome number 6, which is colonial stroke apartheid era justice-related legislation, reviewed and replaced. I need to indicate that we have 4 indicators under this outcome. Our priority for this planning cycle is to review and replace colonial and apartheid era justice-related legislation with the aim of aligning them with the Constitution of the Republic. We will also submit 4 bills and regulations to Minister for approval. We'll also review 3 colonial apartheid era justice-related legislation. 20 rules of court will be submitted to the board, and 10 research papers to the South African Law Reform Commission for consideration and approval. We'll also consider 12 justice-related apartheid and colonial era pieces of legislation for repeal or replacement over the entire period. And as I move to the next slides, we'll just clearly see those details in terms of those specific targets. And if we move to slide number 47, program 3, which is legal services, contributing to outcome number 7, on improving organizational capability and good governance. We would like to finalize, we will be finalizing actually 80% of the expungement within 3 months after receipt of the complete application. And this is indicated on the template below. Now, in terms of contribution to outcome number 10 as well, we'll still submit 3 bills, regulations, notices, and proclamations to strengthen the anti-corruption architecture of South Africa to a minister for consideration and approval. We'll also develop and submit a plan for the implementation of the recommendations of the Commission on State Capture to Minister for consideration and approval. And those details are in the next slide. Now, if we move to slide number 50, Honorable Chairperson, that is program 3 contributing to transforming state legal services. We are prioritizing the transformation of state legal services through implementation of the State Attorneys Amendment Act. We are also focusing on the finalization of policies that will culminate in lowering of costs of litigation and the building of capacity, as well as establishing well-run state attorneys' offices. At a strategic level, we plan to achieve 3% annual reduction in state litigation liabilities by 24-25 financial year. We'll also submit 5 policies to implement the State Attorneys Amendment Act to Parliament for approval. We'll settle 55% of litigation cases and finalize 75% of legal opinions, suggested bills and subordinate legislation, and international agreements within 30 days from date of receipt of the instruction. So the next slide details what I've just explained to the Honorable Committee. Now, the slide number 53, it is focusing on one key priority of the department is to transform the legal service legal profession. So for us to achieve this outcome, we'll increase the percentage of value briefs allocated to the PDI legal practitioners, female legal practitioners, and number of female legal practitioners. We'll also, Honorable Chairperson, allocate 83% and 28% value of brief to the PDI legal practitioners and female legal practitioners, respectively, and continue to empower women by allocating 41% of all those briefs. So that is outlined in the next slide. If we move to slide number 55, on advancing professionalism, human rights, and the rule of law, this financial year, we will develop and submit a framework for the visual repository on disaggregated statistical data for the measurement of racism, racial discrimination, xenophobia, and related intolerances to minister for approval. We'll also develop a national framework for participatory democracy. We'll submit 2 country reports to minister and cabinet, and also will process 80% of the request for extradition and mutual legal assistance matters in the new financial year. We'll also hold 4 engagements with stakeholders towards the promotion of equality courts with the department and role players and submit a national framework for participatory democracy to our DG for approval. So these details are outlined in the next slides. So if we move to the last slide, which is program number 5, our auxiliary services. This program, Honorable Chairperson, is contributing to modernizing and increasing access to justice services outcome. So in this financial year, we will connect one government department or entity to a transversal platform and exchange information electronically and complete one KPI on the integrated justice system dashboard. We will also deploy person verification service to 40 South African police stations. We'll also hold 14 IJS governance intervention sessions this year in order to improve management and governance of the IJS projects. And these sessions include the IJS implementation committee meetings, the IJS board of DGs, meetings with the IJS ministerial committee meetings. So the details are outlined in the next slides. I will hand over to the CFO for the presentation of the budget. Thank you.
Good morning, honorable members.
CFO, we have 5 minutes. We have 5 minutes.
5 minutes, thanks, Chairperson. The budget that has been allocated to support the outcomes that have been outlined before is 22 billion for the current year. It has increased by 2% from the previous financial year. This is mainly due to an increase in the salaries for NPA. It declines in 2023-2024 due to historic budget cuts that has been affected over the period. So the next slide just shows how the budget is allocated. The main portion, the main part of the budget goes to compensation of employees at around 47% of the total budget of 22 billion, followed by earmarked funds. That's where we cannot move funds within different programs, mainly on magistrate salaries as well. And then 14% is allocated towards transfer to entities transfer to entities include NPA also, and also the SIU and Human Rights Commission. With the 5 minutes that I have, Chair, I can only say that the budget that has been allocated, we will try by all means to make sure that the targets that have been set are achieved and it is used in the most efficient manner. We continue to engage with National Treasury and to explain our challenges that we have as an organization, as funds are never enough to cover all the things that needs to be done. That's with the 5 minutes. I thought maybe I can just summarize it, that I'll take the presentation as read. Thank you.
Chairperson, with your permission, that's the presentation of the department. Thank you.
Thank you very much, DG, and to your team. Let me take this opportunity on behalf of the committee to welcome the new CFO. Welcome, Mama. You are welcome to this team of the department, and we're glad to work with you and with the entire team to ensure that the department is turned around. Welcome. Thank you very much. Just before we allow for members to comment, Deputy Minister, we see here that there are reduced and removed targets. Were you part of the approval that those targets be removed? Because some of the targets are targets that were set by Cabinet or National Executive that we are part of. So were you part, did you agree that these targets be reduced or removed? For instance, the target on 30% of companies that must be paid, of invoices that must be paid within 30 days has been reduced from 100% target to 98%. You have other targets, for instance, that involved the percentage of rand value of discretionary procurement allocated to women. The target by government, the Cabinet in 2020 approved a policy that 40% of public procurement should go to women-owned businesses. That target has been removed. So did you give approval? I would have loved if the minister was here, because that is what the minister and the DM should be doing oversight over the department on, to ensure that policy directives from the executive is implemented. So did you give permission or part of the meeting that these targets be removed or some of them be reduced?
Thanks, Chair. Look, you need to go through each target, but the one on some of the reductions in service delivery, I was not in support of the percentages, and particularly the issue of the payment of invoices. I mean, these are invoices that are not meant to have any disputes or problems, so it's not sort of every invoice. I was not in favor of that target. Okay,
just for your, I will take you through the reduced targets first. I've already made mention of the 30 days that has been reduced. And then there's case log reduction framework to be submitted. Okay, that one is fine. Percentage of NRSO clearance certificate within 10 working days from date of receipt of the application. The target in fact, the target was supposed to be 75% for 2022-2023. The target has been reduced to 55%. number of courts.
No, I wasn't in favor of that reduction. I don't know if you want to run through each one, but some of them I may have been in favor of. I mean, that's why it depends on which one, but that one, no, I wasn't in favor of.
Because my problem with the reduction of these targets and the removal, they go to the core of why we are here. Just to make an example of the last one, I would not bother you with others. Number of courts compliant with the strategy on universal access for persons with disabilities. The target 2021-2022 was supposed to be, in fact, it has been reduced from 100 to 27 courts. Now, and from what I was listening to the person who was presenting, the head of strategy, the manner in which he presented the issue of the core of the courts, the 27 courts, is as if there's no indication from the presentations, because this also goes to members of the public. There is no indication or explanation as to why targets were reduced. And if you are listening to the presentations, as if these are new targets. But there is a significant reduction that it will be very difficult for us, especially those that represent some of us, our manifesto mandate, just to agree to a reduction of those. Then the question will be, why am I here?
Yeah, Chair, I think I did on the memo on this right make certain comments. There was a response from the Director General, which I think he would be more qualified to give, but it related to resources, effects of COVID, effects of ransomware, those kinds of things. But I'd rather that the DG and his team explain the reasons for the reductions.
Well, thank you very much, GM. DG, before we just proceed, my understanding, I would not say the committee's understanding, maybe other members would have a different view, is that the plan, it's a promise. It's a promise that you are promising that you are going to deliver on the mandate that you said that you have sold to us. And on the basis of that, we should advocate for resources, that Parliament releases resources on the basis of the plan that you would have sold to us. Now, if that is the case, there are issues that I would like to bring to attention, which emanate from the BRRR that are covered here in your plan. So I will just take 3 minutes to cover some of them. On the audit action plans, irregular expenditure and consequence management, we requested the DG to provide details of the commitment made, that is the ones you made last time you appeared before us, as well as progress report by 31st January 2022. We have not received it. We requested a consolidated report on all outstanding disciplinary matters. We have not received it. The committee requested that the department provide a comprehensive progress report on its infrastructure program, as well as its maintenance program by 31st January 2022, and continue to report on progress as part of the quarterly reporting process. We have also We have also requested information on the plans to invest on ICT technology to speed up the process at the Master's Office in writing by 31st January 2022. We have not received it. The committee requested an update report on the progress of its plans regarding Justice College by 31st January 2022. And the department should be prepared to report quarterly on this item. Now, quite a number of these issues that I'm raising now appear on your APP, but you have not even given us what we have requested. So why should we believe that the department is going to implement successfully on the plan that we are promising? DG?
Thank you very much, Chair. Just maybe to start with the last issues of the BRRR, the 5 reports. We have them available. They can be launched tonight. I guess maybe there might have been a misreading on our part in focusing on the quarterly reporting that we thought maybe there would be the arrangement of us making presentations before your committee. So we can commit that by this evening, these reports are launched. They are available. So we just need to check with our parliamentary licensing processes on how these reports were not submitted to be processed for your attention. The other part,
but before you move, DG, the deadlines is quite clear. And so that we are aware that we do not want to confuse the department. All of them, we made them to be 31st January 2020. We have made them to be 31st January 2022. All of them. The deadline is quite clear. And it was in January, we're now in May. We have not received them. And they talk to this annual performance plan that we are presenting.
Yes, Chair, we accept that in our apologies. And the point I'm making is that it's not like work has not been done. So as you are correctly saying, part of what our annual report will be reflecting on is on the work that has been done in the previous financial year along this. And with your permission, and we sincerely apologize that we did not work on the process to have them reach you. We will make them available.
Thank you very much, members. Honorable Swart.
Chairperson, may I also just congratulate the new CFO. Please let me know if there's a problem with my connectivity because I am leaving the camera off. There's a challenge on my side. But I do firstly want to congratulate the CFO. Chair, I need to also express my dissatisfaction with the fact that the reports were not complied with by our request by the 31st of January. I want to express myself strongly because we need to ask the department whether they are taking Parliament seriously. We asked specifically for certain reports to be given on the 31st of January. It's not acceptable for the DG to just say that work is being done. It's not like work is not being done. And the challenge that we're now faced with is we ask specifically for certain reports to be given by the 31st of January that will enable us to evaluate the plans that we are being presented with. Now, the challenge with the plans is firstly that the Deputy Minister indicates that he was not in agreement with certain of the targets. Now, we need to bear in mind that you correctly point out some of the targets have been reduced. The Deputy Minister indicates he was not in agreement with the reduction. But in addition to that, when we evaluate at the end of the year, we will notice that only a certain percentage of those targets are actually met. So it's a challenge, Chair. When we go on oversight, members of Parliament receive many complaints about the efficiency of different departments of the court sitting, of the master's office, of maintenance. And so can we, in reality, consider these targets, given the fact that justice must be seen to be delivered and that our citizens of the country are requiring us as members of parliament to ensure that it is being delivered? Chair, we see issues relating to budgets. We see issues, I understand, and I think the DG needs to go in more detail as to the reduction in certain of these targets. We understand from the DM it relates to resources, the effect of COVID-19. Sadly, so much has been put at the blame of COVID-19, but we'd want explanations in that regard. And following on the complaints that we receive as members of parliament, I think we need, and we know the challenges the department is faced with. And I'm always saying, yes, it can be attributable to insufficient budget as well, but we need to hold the department accountable. And at this stage, I'm not satisfied that we are able to, given the fact that we need to issue and agree on this budget process. That in general, Chair. I would like to ask in particular, though, some of these targets, and one of the issues that we are always receiving complaints about is the Master's Office. I want to know particularly whether sufficient steps are being implemented to turn around the Master's Office, particularly relating when it comes to targets, but we know the challenges at the Master's Office. We also need to have an update. Who is interrupting me, Chair?
People on the virtual platform, can you please mute yourself?
Chair, we need to also understand the challenges around the State Attorney's Office. I'm not sure whether this is an appropriate time to ask for feedback on the SIU investigations into the State Attorney's Office, given that we're dealing with planned targets, but maybe we can have a short input on that side. And then, of course, on court services, the number of courts that are sitting, the issue relating to the universal access. I think it's disgraceful that that reduction has been reduced from, if I understood correctly, was it from 100 to 27 courts. But the challenge is the sitting of the courts. And in general terms, DG, I would like you to just give us a short input as to the impact of the floods in KZN. And we understand that's a very difficult issue to deal with, but to what degree are court services, justice services, what are the plans to reinstitute those courts that have been devastated by the floods? So, Chair, I reserve myself to ask further questions, but I don't want to take up too much time at this stage. Thank you so much.
Thank you very much, Honorable Swart. Honorable Hon.
Thank you, Chair. Good morning, and with your permission, Chair, I am on a cell phone hotspot because I am experiencing load shedding at this stage, so I'll not switch on my camera with your permission. Yeah, Chair, let me firstly say thank you for the presentation, but in the same vein, I align myself with the pertinent questions you asked and the comments made by the Honorable Swart, in the sense that it is defeating the purpose really of the department's appearances in front of this portfolio committee if reports and feedback that is then requested by certain due dates simply does not appear. So in that sense, it's quite clear that our ability to entertain and interrogate the APP and the budget would have been enhanced if we have received all of the agreed reports by the end of January. And of course, this is not, Chair, and I think this must be stressed, just because this portfolio committee wants to be seen as effective, or strong in its oversight, this is really informed by all of the issues that are plaguing this department and the effect it has on the lives of South Africans. So at the outset, I want to stress that the context of this specific interrogation, Chair, is the fact that we simply have to bear in mind that ordinary South Africans out there who are dependent on this department and the various branches and entities of this department for services are being left in the lurch in a specific time in which people are confronted with a myriad of other issues as well. And in that sense, the plight of people, whether it is at court, the master's office, are really, the effects are compounded by what is going on in the economy. And in that sense, this department and its entities could have assisted people who are specifically dependent on obtaining what is due to them in terms of finances, by the fact that ultimately this department is not functional as it is. So let me move on then to specific questions and comments, Chair. Firstly, in respect of slide 5, and the ransomware attack, and also the assurances given by the Director General ultimately that this department is now on moving forward from the ransomware attack. I want to appreciate that comment, but then slide 5 is worrying in that it is phrased very much in a way that creates the perception that the strengthening of security protocols is something that is still going to unfold going forward. So I firstly, in terms of a pertinent question, want to ask what has been done in terms of bolstering the security protocol of this department, and whether, as we speak today, the department is satisfied that if a ransomware attack is to happen tonight or over the weekend, that it has at least a good chance of fending it off. Chair, then I want to move on to the ongoing saga about the court recording technology. And I want to say that I believe that unfortunately our meeting towards the end of March seems not to have concluded the matter, in that on the 17th of April, the Sunday paper report, and I think it was also carried on the News 24 platforms, reported in detail on the effect and the secondary trauma suffered by people, specifically in the sexual offences court. But what is more worrying is that news report made it quite clear that data-centrics, more or less a month after our committee meeting, taken control of fixing what was wrong with our court recording technology at that stage, because they reported, Chair, that at that stage they were in the final phases of concluding the contract. So we sometimes, of course, we all know that the media doesn't always get things spot on, but I must ask today for a further explanation of the very firm undertaking and communication towards the end of March at our meeting from the department that data-centrics was already on site, versus their firm statement on the 17th of April that they were still at that stage only in the final stages of concluding the agreement. Then, Chair, if one looks thirdly at the issue issues brought about by a variety of factors. And as the Honorable Swart said, we must now move beyond the point of explaining or blaming COVID-19 for everything. And that is the caseloads or backlogs, specifically in our criminal courts. We've been made to understand that a integrated approach with a specific department-led initiative is going to result in a backlog plan. And it is somewhat worrying that this presentation and the APP does not in any way or form speak to this. I think we're way beyond the point now where this department can say, specifically also, as I say, given the fact that we were made to understand that this department will play a leading role in also at least coordinating the establishment of a backlog plan, that this department can simply say, but this is really matters the NPA and the judiciary should focus on. Then, Chair, slide 13 talk about a sheriff's bill. So I want to inquire at this stage how far the development of this bill is, and that this comment or request is informed by very specific issues that seems to be plaguing the sheriff's industry, and I want to maybe more specifically also ask to what extent the legal profession is involved in the recrafting or redrafting and recreation of the whole architecture around our sheriffs. Around the Master's Office, I agree with the Honourable Swart, and I also want to say, Chair, that if I look at the specific targets around the Master's Office, unfortunately, these do not in any way or form address the real issues, in my opinion, at the Master's Office. And the issues, in my respectful opinion, is simply this, and that is that at this stage, there is no way in which the Master's Office can claim that it, through its communication with its clients, its stakeholders, place people in a position to know why matters are not progressing. So the Deputy Minister would know that I, for example, in respect of one estate at the Cape Town's Master's Office have asked him for assistance, and he's been very helpful. But the reality is this, it was quite clear that this estate has in no way progressed, and it's simply because the attorneys, and it's attorneys that's dealing with it, were not informed by the Master's Office what was preventing them from issuing the letter of executorship. So the target says, once we are in possession of all the necessary documentation, we have a target of issuing the appointment letter within a specific amount of days. But Chair, it is clearly not acceptable then for the master to, in the absence of all the necessary documentation, not communicate with those who represent the estate. And in that sense, I believe that type of issue is ultimately causing massive headaches to both legal practitioners, but also ordinary people who have to access master's services. And unless there is also going to be placed a responsibility on master's offices to effectively communicate what is amiss in terms of the compliance documentation or the filing documentation, the perceptions and the reality around the master's office is simply not going to improve. Then, Chair, I agree with the Honourable Swart comments around the state law advisors as well, and I see the presentation centers, and rightfully so, about limitation or more effective cost management. And then there's a massive emphasis now on the settlement of matters. And of course, we all know that the timely settlement of matters can be an effective way of dealing with specifically costs. The worry, however, is this, that these targets around the state law advisors in no way speak to the improvement or of the quality of the services from our state law advisors. And I want to ask what specific measures are being put in place in that regard. Then, Chair, if one for a moment turns to the sexual offences courts, it must firstly be stated that it remains a worry that there seems forever to be delays in the rollout of these. And then in addition to that, I want to ask the question, because colleagues would recall that when we were really expediting from our side the processing of the 3 GBV Acts, we were at all times assured that a parallel process was already unfolding within the department to, on a very speedy basis after the assent by the President to these acts, come up with the necessary regulations that is, of course, a requirement for final implementation. And at that stage, we were informed that regulations will follow within a very short space of time from the assent. Now, the assent happened towards the end of January. So I want to ask, where are those regulations? Then in terms of court infrastructure, Chair, I must say that this is, in my view, a ticking time bomb for the department. And I want to use the specific example of the answer received from the Minister now in respect of the temporary closure of the Rustenburg Magistrates Court Complex. And say if this is A, the trend in respect of maintenance of our court infrastructure, and B, with respect the attitude towards it, then we're not going to diffuse this ticking time bomb. So in response to my question on this, Chair, the Minister admitted that in 2007, 15 years ago, this court was first identified as a court in need of major maintenance work. And despite that, as we speak now, the court was temporarily closed, then measures were put in place to at least get it operational again. But as we speak now, the contractor that is supposed to undertake these major works are still to be appointed. That's the first issue. The second issue is, however, that the department in the answer claims that they are not to be blamed for this. It's all public works again. And if that is going to be the attitude around major maintenance works at courts, and we must remember Rustenburg is one of the biggest centers in this country. It's not even deep rural or former neglected areas, then Chair, we must say to one another that the attitude of this department around these issues are contributing to the dire situation around our court infrastructure. Similarly, around contract management, I must say up front that I'm not convinced, and I'm glad, and I also add my voice to those who have congratulated the CFO on appointment, but I'm not convinced that the mere fact that we now again have a permanent and full-time CFO appointed for this department will be the magic wand that will fix contract management issues. And I renew the plea, Chair, that we be afforded full information as to the contract management system that going forward will prevent the type of lapses and failures that led to our courts being unable to operate because of the court recording technology contract lapsing and not being renewed in time. And then lastly, Chair, on slide 61, and referring back to the interrogation of this issue already on Tuesday when the minister appeared, I must say that the targets and the manner in which the APP goes about the integrated justice system, with one KPI being identified in the upcoming 2 financial years around this system, unfortunately just strengthens the perception that this is a dead horse that are being flogged. But somehow we also spend a lot of money on feeding or buying the necessary food and inoculations and etc. for this dead horse. So where the food and the medicine is going, we as a committee must wonder. And I must say that it is totally unacceptable with the way the APP just goes about this very important project. And it from our side, we must say that it would seem it's just unfortunately repetitively money being poured down the drain in respect of this project. Thank you.
Thank you, Advocate Breitenbach. Members, we must also be aware that we need to also afford time to South African Legal Aid Board. They are with us. We need to also have time for them. Please bear that in mind. Advocate Glenis Breitenbach.
Thank you, Honourable Chairperson. I'm covered very largely by and comprehensively by the previous inputs. I just have 2 things to say. I need to know what consequence management is, or what measures have been put in place to ensure that expiring contracts are attended to well prior to them expiring. We cannot have this situation developing where contracts expire and then ex post facto money is totally wasted on stopgap maintenance issues, and contracts are then negotiated at gunpoint. It's just nonsense. I need to know what programs are in place, and this is not a new thing. It's been coming for many years. So I'd like an explanation on that. And then I really need a more comprehensive discussion about the measures and mitigations in place to deal with the shocking state of infrastructure, both office infrastructure and court infrastructure. It's just and DCS infrastructure is equally dilapidated. There must be something in place. I want to know what those plans are. We can no longer allow this skin deep glossing over of very serious issues. It's enough. Thank you, Mr. Chair.
Thank you very much, Honorable Breitenbach. Let me scroll. Honorable Velmani, vote to hands.
Good morning to everybody. Just checking the interpreter. Thank you to the department for your presentation. I would like to add my voice to what the chairperson has said about the reduction in targets. It is also a huge concern. And also the budgets are reduced, and it is a concern. Yes, we do know that budget cuts are not a new thing. So Chair, if you could just be patient with me, my notes are a bit all over the place. So I'm just, okay, so my first question would be in terms of court intermediaries. That is a very important function, especially during the course of our deliberations on the 3 GBV bills. And the intermediaries are very necessary to support the victims. As I understood it, the intermediaries, the numbers of them were reduced and also their salaries were reduced. So in this APP that you are presenting, it says there will be 20 court intermediaries introduced, but will that, so that will be in the sexual offences courts. So these 20 intermediaries, will they be enough that you, the 20 that you plan to appoint, will they be enough? Will they all have the capacity to do the huge amount of work that is required of them in the sexual offences courts? My next question is related to the audiovisual system rollout. We last heard that the rollout was delayed, but now in this 2022-23 APP, is the audiovisual system ready for rollout? And what is the plan to roll it out, considering that it was delayed previously? And furthermore, so I see that in the Office of the Family Advocate, you know, it's a big focus for children, but that budget has been reduced. So I would like to know why specifically that branch, where the victims are mostly children, why was that particular budget reduced? And I think perhaps the other members have covered this point about the sexual offences cases backlog. This backlog does not help the victims, especially if it's, you know, the victim is the one who went to make the case. And these kind of delays, and also when it takes too long, you know, it just gets written off. So how will the department ensure that the backlog, specifically in relation to sexual offences cases, that backlog is reduced? I also see in the reports of the oversight visit done by my members, the facilities, the infrastructure, and the master's office in Limpopo, for example, that it's just a lot of stairs and the lift is not functioning. People with disabilities who use wheelchairs, who can't access the lifts, the elderly can't access the building. So what is the department doing to ensure that especially the lift is functional so that it allows access for elderly people as well as people with disabilities? I understand also from previously that the Solicitor General, at that time, it was a contract limited, it was a limited contract, limited year contract. So I'd like to know if the contract has been extended. Have the discussions taken place? How far are we with that particular aspect? And then coming to access to court services. Just this morning, this very morning, I received a video of a deaf person. They were signing to me, he needed a court interpreter, a sign language interpreter. He is in the magistrate's court and he has been waiting for the interpreter. When the interpreter eventually arrived, it's this elderly person who's signing the client did not understand. So again, I'd like to make the request that in the courts, the South African sign language interpreters that are used, they need to be proper interpreters. This is part of access to justice and access to courts. So this old interpreter, you know, their parents are deaf, but I mean, it's like from years ago, and he doesn't use the current language, and we know that language evolves. And so this is just a waste of time for the client because they're supposed to have an interpreter, but they don't actually understand the interpreter. So please, can the department work with organizations who work with deaf people? I make this request again. And then coming to the percentage of invoices paid within 30 days. I think the chairperson has raised it that the target was reduced from 100%. Why have you decided to stop at 98%? Why have you reduced it to 98%? I will stop there, chairperson. Thank you very much.
Thank you very much, Honorable Janji.
Thank you and good morning to you, members and everybody in the meeting. I think, Chair, you have set the tone up front. And in doing so, you have covered a lot of the issues that I was worried about. So I want to thank you for that, because you normally come at the end, and I can understand, I could see, I could feel it in your voice, why today you started from up front. It helped, and I'm hoping that we're going to get proper responses to that approach. Chair, I have, in line with your request, I have very few, just about 3 issues I want to raise. And in fact, I would have loved to ask this and let them answer and then do a follow-up, but I will have to come back for a follow-up because I just want to ask very direct questions, Chair. The first one, as you indicated, Chair, this exercise is a department coming to us together with the executive to say to us, here is our proposition. Here is our plan. This is our promise of what we're going to do, this forward-looking thing. And I always make the point that when you make that, you're supposed to be on top of your game because you are the one proposing, and you should have prepared to do that. It's different when we look at you in terms of how you have performed, which is the annual report. So this exercise is supposed to be the most easier one to do. And therefore, with this exercise, in addition to the many critical questions asked by my colleague, that there's one pertinent question that has to be answered, not by us, by the department, even before they come to us when they put these plans together. And I want to ask them that question. DG and DM and the DG. Is what you are tabling in front of us, is this annual performance plan that you are tabling in front of us credible? Because that's what we're looking for. We look for what you put in front of us, whether it is credible, it is a doable plan, it is achievable, it is well resourced and supported, and whether it is not just a thumbs up. So really my simple question is, and I want you to answer this honestly. Have you done all of what you have done, brought this entire team that we have in front of us? Are you presenting a credible plan to this committee? I want to have a follow-up on that depending on their answer, Chair. Because that credible plan gets to be followed and linked with many other things that, having sat here, listened, read the documents, I have missed to see where those things are. So I would like them to just answer that very simple question. And I want to have a bite after that. But just a comment, Chair, as I leave that, is that the DG, in his opening remarks, makes an important point, because it's correct. As the committee in 2020, we said, based on our assessment, that this department needs a rescue plan. It's a department that was gone. And we said it needs to be rescued. We deliberately said we don't want a turnaround plan. We want a rescue plan. the DG is saying here they've opted for a turnaround plan, which must mean that you would have chosen to do the cosmetics than to do the comprehensive work. Now, you know, cosmetics is that Vaseline that you put on instead of taking a proper shower. Cosmetics, you look better. I really, because he goes further to say they are turning the corner. From what I've read, from what has been presented, I'd like them to tell us where they are turning this corner in this turnaround plan that they are presenting, instead of the rescue plan that we wanted. Because they've opted for that, and they felt that based on their own analysis, a turnaround plan is likely to address all of the issues that were raised as problems, and so on. I'm going to pause the chair because I would want to have a follow-up post their response. Thank you.
Thank you very much, Honorable Janji. I would also like to ask some questions that when they respond, they would take them into consideration. In your APP, in fact, you said 2022 is the year of the community, and extensive programs to interact with community are going to be embarked upon. Now, what I would like to know, what are the specific deliverables for the rollout of this outreach program? Because we need to see deliverables so that we can be able to measure you on the basis of that, and we can be able to ask Parliament to fund what can be measured. What cannot be measured, it is not done, and what is not done can be funded. Was the structure of the department, the structure that you have now, approved by the DPSA? And if yes, when? There seems to be a lack of agency in dealing with vacant positions. And to support that, you have even removed the 10%. In fact, we have changed the 10% to be 10% of vacancies over the medium term. To us, the issue of vacancies is an urgent one. So changing the target of 10%, which is universally accepted by government, that you must keep your vacancy rate below 10%, is just unacceptable. Also, we have indicated that service delivery plans, these service delivery plans that you are indicating here, you have had them since 2011-2012 financial year. Now, how are these service delivery plans differ from the old plans that you have always had since 2011-2012? There are no indicators in the 2022-2023 APP which measure client satisfaction with service delivery in respect of critical justice services. Can you be able to explain to us why? And then there's also this issue of courts audiovisual solutions that has been procured by 28 February 2022. It was supposed to have been procured by 28 February 2022. Can you confirm to us now that that has been done, so that we can be able to make follow-ups if that has not been done? Can you confirm whether it has been done by the 28th of February this year?
Did you hear that question?
Now, let me add to part of the issues I did not raise with respect to removed targets. Maybe for the ease of reference, I think let me just name them. Percentage of significant findings resolved, it was removed. Percentage of rent value discretionary procurement allocated to exempted micro enterprises and qualifying small enterprises, that was removed. Percentage of disciplinary hearing finalized within 90 days from the date of the matter, that was removed. Number of backlogs on disciplinary hearing cases for misconduct resolved, that was removed. Number of grievance backlog resolved, that was removed. A percentage of rent value of discretionary procurement allocated to women, I've already spoken to, that was removed. And then on the reduced targets, percentage of undisputed and valid invoices paid within 30 days, that was reduced to 98% from 100%. And the percentage of NRSO clearance certificates within 10 working days from the date of receipt with the application projected target was 75, now it's 55. I've already said that. I've already spoken to the people with disability. Honorable Nivot Jochans has made mention of the lift in Polokwane that is not working, and it has not been working since September 2021. Now it's May 2022. The lift has not been working. At state legal services, the vacancy rate is 11.4% above the national norm. Under Master's Office, just to add on what Honorable Swart has Honorable Horn has raised, the department says it will implement a robust strategy for the transformation of the services by the Master's Office. Now, what are the deliverables? We want to see the deliverables. What are you going to do that at the end of the day, if all of those things are done, they will result in a transformed Master's Office? What are the indicators to measure progress? That is what we would like to hear from you. The position of the Solicitor General was advertised. In fact, he has been in office since the 2nd of April, 2020. And can you brief us as to when is this position going to be permanently filled? And then policy on the management of state litigation contingent liabilities has been removed. Then why? Why was that removed from the APP? Can we get a briefing, maybe on another time, a briefing on the briefing patterns? Can you tell us, and what are you going to do with respect to the fact that the Office of the Legal Services Ombuds is not operational? Why it is not operational? When is it going to be operationalized? Currently, there is 1.8 billion in the President's Fund for Community Rehabilitation Projects, that is under the TRC, that were recommended by the TRC, but the department's APP no longer contains an indicator to measure progress. Why? Community Rehabilitation Project team was established in 2017 to coordinate and fast track the implementation the implementation, it is unclear what progress has been done with respect to that. And it's a very emotive project that does not seem to be getting the necessary priority. There is an IJS assessment report. We requested a copy of that report some time back. We have not received it. In 2021-2022, the department still had 13 of the recommendations to implement. In 2022-2023, the indicator has been removed. That is the IJS. The indicator has been removed. If these recommendations, I think the 13 recommendations were implemented, how were they implemented? Now, the issue is that in the plan, there are quite a number of lofty things with respect to IT for that and IT for that. But when you go to courts, we went to Polokwane High Court. We went to the office of the DPP in Polokwane, the office, the chambers of the judges, the legal aid, a master's office. The situation is very bad. I don't think any of us can be in a position to sit there for 5 minutes. It's very hot. There are no aircons. You go to the Supreme Court of Appeal. There is a big generator that only lights the passages. So when it is load shedding, the court cannot work. It's a big generator, just lights only passages. And you can't say to me that is public works function. The issue would be, what is your interest when your courts cannot work? When the courts cannot work, when we have a big generator that has been procured, but that generator is only relevant in as far as lighting passages, not assisting the functioning of the court. We went to Polokwane High Court because those are the things that we think, or I think for me, if we want the justice system to work, we should start with those things. Don't promise people Rolls-Royce whilst you cannot be able to provide them with Toyota Corolla. In Toyando High Court, a big accident nearly happened. 2 offices, the bulbs just blessed, and the courts, the offices of the chambers of the judges, there was fire there. So if those judges were in their chambers during that time, we could be talking something else. There is a wiring problem. Those are the things that for us, because what I would like to know from you, DG, is before you go to specific issues around infrastructure, globally, how much will it cost to fix our court infrastructure? Do we know how much will it cost? Do we know the extent of the challenges as the department? And then you can say if it will cost 100 billion to deal with our court infrastructure, this is how we are going to be budgeting. This is how we are going to be breaking this 10 billion into maybe five medium-term budget cycles. Do we know that? So what we are trying to diagnose, in fact, what we are trying to develop a strategy to turn around, have we clearly diagnosed it? Over to you, teacher.
My apologies, Chair. Do I answer this one only or deal with them, all of them comprehensively?
Sorry, teacher?
Now, I was asking, I'm answering your last question that we're raising for you to continue, or you are giving us a chance to respond to all the questions?
No, you can just respond to all of them, teacher.
Okay, thank you. Thank you very much, Chair. We have colleagues here who will deal with the different deputies, Director General, who will deal with the specific issues that relates to their work, and I'll come and analyze. Maybe the first question I would have asked is, there was a question by Honorable Janchi that appeared like required us to answer before you could ask a question about whether we're presenting a credible plan. Taking into account all the objective factors from our part, objectively, we are presenting a plan that we think is credible. So I'm not sure, Chair, whether we then have Honorable Judge then having made that statement, ask us questions so that we can deal with them comprehensively.
I think answer all the questions, and then Honorable Judge, if he wants to have a second part, then he will come back, because I think his question is in fact, his follow-up response is based on all of the responses that you would have made to all of the questions asked, and then he will make an assessment whether this strategic plan is credible. So I think you can proceed.
Yes, Chair, thank you very much. Yes, maybe Chair, in a synergized manner, the issue of infrastructure, at least from the time that I've been a Director General to here, when our appearance is here before this honorable committee, this is a serious matter that you have been raising. But maybe in plain terms, I must say that we need your assistance as a committee. Because the reason why DPW gets referred to is because of the law, which has been passed by this parliament, that gives the Department of Public Works and Infrastructure the responsibility to manage the facilities. So it's a historic fact that we can produce all manner of communications that we do raise with Public Works. That's why even the minister and the deputy minister intervened to a point where a ministerial meeting was held in February to raise all these challenges. And that's why we're explaining that out of it, a plan is emanating that the department will be given the responsibility. And it's not only this department that is affected by the work that Public Works has to do. It's a wide range of other departments as well, who have, including our sister department, Correctional Services. So including the issue of Rustenburg. I went to Rustenburg myself last year, even before it became an issue for the municipality. And actually engaged with the acting Director General of Public Works on it and raised all those concerns. So I'm making a point that it comes across in the different concerns that are being raised. But it's a major issue of dependency. That's why even last year during the annual report, I did openly raise that issue. So if it means at some point maybe a joint meeting of the two committees and the two departments appear here, it may assist us, because it is the reality that the state of our facilities is not good, and it's not because of the failure of the department. And we hope that the plan that we have presented to and the proposals we have made to Public Works on how we deal with these matters going forward, including the issue of generators, is not a straightforward, easy issue that is not Public Works. It's not only generators, including the issue of boreholes, which there's a problem of water, we know that, in many of our communities. And directly then the costs as well get affected. So all those processes that we have to depend on Public Works, and even if they were to wake up tomorrow and say we are delegating all this responsibility to you, but historically the department would not have built the capacity in terms of skills that will be required basically to do that work. It will still be an issue again of requiring a budget from Treasury and say, look, we need to hire people. Currently, the number of people that we have that are responsible for facilities, because historically, they've just been doing facilitation work. I think they are not even more than 10. And we're talking about almost 800 buildings across the country. So I mean, from head office point of view, maybe one per province. So it's an issue that is not just for us here because of the limitation of the law and the responsibility that the Department of Public Works has. So I thought in broad terms, that's how, and it's not an escape, it's not a scapegoat on our part. It's a reality. I know that you as honorable members, you will know about the other challenges that other colleagues raises concerning DPW. And previously, I also forthrightly raised the issue of State Information Technology Agency, SITA, that those are the twin challenges that we face as a department. That part of the reason why we even ended up with the challenge we had an investigation going on the CRT, and a full report will be made available to you. There was a SITA factor, where you have requests for quotations that are being guided by the law saying that it has to be done by SITA. And some of it doesn't take into account the developments that have happened in the technological space over the past 7 or 5 years. But we still have to come here and account, but there's the reality of SITA, and I'm not the first person to raise the challenge of SITA. It has been raised by even other ministers in other committees. So I'm saying, even in that respect, we are making a plea that we need your help as well in dealing with that issue. But then coming down back to some of the issues that you have raised, you have asked about the structure. We did review a structure of the department and finalize the process, at least from our part, which for many years, the department didn't have an approved functional structure. That was say, I think, for more than 10 years. So that was the first part that even in our turnaround strategy, we had to say, we need to have an up-to-date structure that can at least seek to address the issues that we're seeking to deal with. And the structure was submitted to the Department of Public Administration for concurrence. They did make some comments, which were mainly around the budget. And the department has now worked on the budget and confirmed that the structure that we have proposed will not cost more than what we currently are spending. And if anything, the proposed structure will help us to manage the little resources that we have. And I'm advised that it's in the ministries waiting for minister's letter to write back to the Minister for Public Service and Administration, responding to the questions that were raised, particularly around the budget. The vacancy rate, Chair, you did raise this. I can confirm to you that we have reduced the vacancy rate at senior management level to below 10%, which is the acceptable level. You'll recall last year, even when the minister gave a political overview, the vacancy rate was sitting at 27%. Chair, in the space of a year, we managed to fill more than 12 chief directors posts, and we managed to fill more than 11 directors posts. And not because those posts just became vacant last year. Those posts had been vacant for some time. So in terms of the capacity of the department, when you talk about ability to deliver and performance, you could even say the department was hollowed out. There was no capacity because those posts were not people retiring or just leaving the department. They were posts that were there. So this is the progress that we can say we can report we have made. And my understanding is that we continue with that commitment, especially the requirement that we have vacancies below 10%. So we're not moving into a midterm period. It is a requirement even this year that for those that will be above 10%, we'll continue to work hard to make sure that we bring it down to the acceptable level. Now, if you look at the 16,000 staff complement of the department chair, what we have to appreciate is that the big base is mainly at the lower level, which is your level 1 up to level 8. So the majority, the constitution of the staff complement is your core class, which are mainly your level 5, entry level. So you have a high turnover rate at that level because ordinarily people will apply to take those positions to be absorbed to the system, but obviously they'll be looking for opportunities somewhere else. However, that's not an excuse that will not keep vacancy rates below the 10%. I want to assure you that we remain committed to making sure that we keep that below that point. The position of the Acting Solicitor General, we are working on the process with the Department of Public Service and Administration. The requirements are that we have to have the post job evaluated before it can be advertised. And those processes with any other state agency that has expertise on it, we should be able to give a quarterly update on it. Is being finalized because there were a lot of things that had to be taken into consideration, but that's not yet yet, and that process is being finalized. The year of the community.
Sorry,
and the specific.
Sorry, DJ, I would like some specifics because this post was filled on a temporal basis in 2020. And up to now, we have not finalized it. And we did, I think, as a committee last year or year before last, indicated to you and to the minister that there needs to be certainty around that position. Now, to say there are a lot of things, the job evaluation and all of those things, it's not good enough. I mean, when an appointment was made on a temporal basis, immediately then you should have done all of these things. They can't take more than 2 years.
Yes, Chair. I guess, Chair, you will recall processes like this because they require the Department of Public Service and Administration. So beyond at least maybe for the year that I've been in the office, they are in the main human resource related processes. And you'll recall that I think the Deputy Director General for Corporate Services was recently appointed as well. So the issues, if you move back on the department up to 24 months, you will realize that in terms of the capacity of the department there were many challenges with vacancies across the board. And that meant as well that it was not only capacity in terms of the numbers and warm bodies, but it meant that capacity also in terms of the skills, the know-how, and the appreciation of processes that had to be followed in respect to certain matters. I do take that point, and that's why I'm making a commitment that in the next appearance, it will not be about work being done, but it will be the specific a report that says this is the progress, because there were many issues around, for example, the requirement for public services that all the jobs in the department must have been the vacancies or the posts, even those that are occupied, must have been job evaluated. Even the job, the post of the Director General of the department was never, for many years, there was no job evaluation report. And you'll recall as well how long it took to have that post filled, because that process of job evaluation had to be initiated. And it then clearly, at the time, appeared like the knowledge and understanding of the processes that needed to ensue was limited. So I take that point that you did raise it earlier, 6 to 12 months ago, but progress is being registered in this respect. So next time the update will be that the post is being finalized.
But DG would also appreciate that our interest in this position is a position that is created by an Act of Parliament.
Yes, and with it, there are other processes relating to other processes, but they then get governed by certain processes that require the Department of Public Service and Administration. So those are the processes that need to unfold.
So now, by when should we expect that at least there's going to be a finality on this issue? Because we work on project timelines, and we cannot, it was part of the problem, if you are chasing a project that has got no timeline, it makes everybody to be very lax. So because this is a creature of statute, and it is in our interest that statutes that are passed by this parliament are implemented. We know that it has come to an end on the 2nd of April this year. That is the acting since the 2nd of April 2020. So it is in our interest to know as to when should we expect a permanent appointment.
Currently, it's not vacant, Chair. The minister did within the regulations extend by 1 year. So I think that was meant to take into account that the process has to be finalized before the lapse of that 1 year. Now, we can here say this is the timeline, but there are dependencies beyond the job evaluations. This is a process that will require a normal cabinet process on the filling of senior government, senior management posts that have those kind of processes, similar to Director General, Deputy Director General, the CFO process as well was the same. So if here and now we make a commitment and say in 6 months, we can only seek to commit on what we can control, but what is outside of our control, which will mainly relate to cabinet processes, I think will be a very difficult commitment to make. But for the part of the department that we are allowed to deal with, we commit ourselves to say at least in 3 months, those processes must be outside of our control.
Deputy Minister. Deputy Minister. Yes. I know that cabinet processes, once submitted, they do not take that much. Would like you to raise with the minister that we are generally not happy with the fact that there are too many acting appointments and very serious critical positions. Be it on the Department of Justice or Correctional Services, you still have an acting national commissioner. These things should really come to an end, because it is difficult for a person to really give strategic leadership if that he or she does not have some form of tenure.
Sure.
Thank you very much.
Yeah.
Thank you very much, dear. Proceed, DG.
So, yes, as I was dealing with the issue you have raised around the year of the community, the specific deliverables. Now, we are one department that, in terms of the responsibility that we have, interacting with the community is not a negotiation. It's not negotiable. Now, in terms of the program, the general observation is that there wouldn't be a satisfactory number of South Africans who know about the services that the department is responsible for. And yet the services directly impact on the poor, the marginalized, living in the outskirts of the country. So the idea is to reach out to the communities, and we are inculcating this approach to all of us, from our court level officials, including actually the members of the magistracy, the prosecution, to say we need to educate and engage members of the community and get feedback about their experience of our services, but also to make sure that they appreciate the processes that they have to follow in order to access the services, including taking services to places that ordinarily would be far away from our service points. Take an example, most of our services are presented or are accessed through our courts. And in some cases, it's more than 50 kilometers radius for people to reach our courts. So the idea is to take those services through this engagement with the communities on a regular basis, be it monthly or weekly basis, and educate them, but also provide those services during that engagement. So in the form of having stalls that provide information in the language that they understand, as well as, education in general around the constitution and the rights of the members of the public. So that's why it's a significant part. From the milestones that at least were presented from the APP, you'll see that we've pitched it at 250. Because this is the first time we're trying to measure, it's a 250 events on the justice services, and then they will be devolved around our provincial offices. Each province will have to take a certain number of events that they have to do. But at the least, even the officials who are based in courts, we have said on quarterly basis, working together with the magistracy, with the NPA, Legal Aid South Africa, and others, will have to reach out to the nearby communities in their clusters and have these events on a wide range of issues. But particularly as well, even around the GBV, we're positioning the department to be at the forefront of fighting against the scourge of GBV. So in the main, as well, around the issues of the constitution, as we celebrate the 25th anniversary, we've identified 150 events that at the end of the financial year, Chair, we should account for as a minimum. We've already started running provincial symposiums, across the country on specific issues of the constitution, having debate, so that by the time we convene a national conference in a year, we take into account the views that will have come from the ground. And this will entail us working, with Saga, faith-based organizations, and many other societies, organizations that are doing community work, including community advice offices and other human rights organizations that will be partnering with. So those will be really the details, but it's a program that we've just launched now, and I think it will be maturing, but we have made ourselves those commitments. And the idea is that by the end of the year, we should be able to conduct a survey and ask members of our communities and say, what do they think about the justice services? Are they accessible? How are they treated by the staff of the department, whether in the master's offices or wherever they are? But the whole idea is to say, how do we also improve our footprints beyond providing these services through the courts? What arrangements can we make in terms of making sure that we reach out to those community services provided and return back to the centers where we ordinarily operate from? The report, Honorable Horn, on Sunday newspaper, I want to give you this assurance, and if the journalist who wrote that article has the courage of his conviction, I'm willing to have him appear here and directly contradict the story that he wrote. Because it's not true. And he knows himself that it's not true. But they have to sell newspapers. And I guess if they create an impression of a government department that is not working in ordinary government, it is likely that they will attract more buyers. But it's not true. What we told you here when we appeared a month ago, that we had a contract with data centric civic military produce documentary proof. We can do that. Even by the time we publish that service, Data Centrics was already on the ground, across the length and breadth of this country, attending to the maintenance of those court recording technologies. Now, of course, he mentions a case that is 6 years old that is not being preserved, that is not being concluded. The challenges with the court recording technology only started last year in August. So surely it couldn't have been because of court recording technology, because the contract with Data Centrics only expired in 2021 in April. And it would have helped if he had our numbers, if he had specifically given us the case. Even now, we're struggling to understand where is this case, because indeed, it is our interest that matters of that nature be finalized within a reasonable period of time. Now, in relation to the backlog plan, the department had committed to develop a backlog plan, and that plan was finalized. So the department will be central and playing a leading role in terms of dealing with the issues of backlog. As Honorable Hon has acknowledged, we are not the only player, but we have to play that leading role. It may not be appearing in the APP that will be playing that role, but in terms of the plan that was in the APP for last year, it specifically raises those issues that will be convening our colleagues in the JCPS cluster, the police, and all the other players who have a critical role to play in making sure that we deal with the issues of backlog. The issue of the cause raised by Honorable Swart that were affected by the floods in KZN, the report that we had, and I think in our answer to a question in Parliament, we did reflect this, that we had almost 30 cores that were affected. But those cores, within a space of 5 days, they were back to functionality. Because in the main, some of them it was mainly the leaking roofs that were historical issues that were waiting for public works to attend to. But second to that as well, there was just an issue of officials who were affected due to roads that were not passable, but also with the flooding of some of the courtrooms. And it may not be full functional, but those courts are continuing to sit, and we are engaging with public works to make sure that those problems that were exposed by the flooding are attended to. I will ask my colleagues to deal with the specific issues that have been raised. I'll ask the Acting Solicitor General, Mr. Pandelani, to deal with the matters around the contingent liability, policies on contingent liability. Now, Chair, what I must explain, if you look at the comparison that Chair you have indicated about some of the things that were in the APP last year, those targets, some of them were time bound, meaning that if we sought to develop a policy on litigation, coordination of state litigation, if it's done, it's done, and then it will not come again this year as development of a policy, but the policy has to be implemented. And I think the same applies to a number of issues that are corporate services related that we have picked up. But those issues have not been dropped, Chair. There are specific requirements that on planning from the Department of Planning and Monitoring and Evaluation that we have to comply with. We have operational plans that have to carry some of those, all those work that, all those targets that will have appeared last year that are being carried at an operational level by the different branches as led by the Deputy Director General. So the Solicitor General will deal with that part, and Mr. Malema, who's the Acting Deputy Director General for Court Services, will seek to address those issues, particularly around the reduction of the courts that can be accessible, made accessible for people living with disabilities, and the other related court services matters. And the DDG for corporate services will deal as well with the issue of the infrastructure. But maybe before I give over to my colleagues, all of my colleagues, and the masters, the chief master here, I would want to address the issue of security around our ICT. Look, I guess we have to face this reality. And we did make this point, and the minister has on several occasions as well made this point. That the challenge of IT that we have to deal with in the department is historic and it's a legacy issue, and it cannot be resolved overnight. The approach that those who were here before us had taken over years was to manage our IT through consultants and outsourcing. So there was never an internal capacity that was built in the department. Now, as a result, because from 2019, from the midterm strategic framework and the priorities that the minister highlighted, you'll have seen that modernization became a big issue, that the justice services have to be modernized. But the reality then became different in terms of internal capacity, that there was no capacity. And so part of the challenges that we had to face, I did make this point last year, that even when we expressed the ransomware attack, it was not a question of if, it was a matter of when, that one way or the other, knowing what I know, having seen what I have seen, that we have an obsolete ICT infrastructure. And that's why after the ransomware attack, we sat down and say, what do we have, what do we do? And we came to this reality and realization that we really have to build from the ground. And that's what our plan is focusing on. And that's why from a strategic approach point of view, we have to just accept that we need to have a branch to be driven at a Deputy Director General level, because the department is big and serious backlog and so far as the ICT infrastructure. So the plans that we have and our focus in the first 6 months of the year is to focus on building that capacity, foundational infrastructural capability. And including the fact that we still have computers in the system that are more than 10 years old. And no matter what you can do in terms of security firewalls, but if you have in some of the courts such old infrastructure, it's already a recipe for disaster. So those are the basic things that we're trying to deal with. But at least from my limited knowledge of IT, you can never say that you're 100% foolproof. Even developed countries who are expected to be highly modernized in terms of technology battle with security around this issue. They get hacked, attacked, left, right, and center. And I'm not saying this is an excuse. I'm only saying we are mindful of that reality, that at least given the state of where we are more vulnerable. But it's a global challenge that everyone is facing. Even institutions, even in the private sector, they can never come here and say they have this capability that makes them to be more than 110% protected. No one can make that claim. Everyone is vulnerable. However, we have learned from that, and that's why we're beginning this journey, and we'll be happy to take your views and support and proposals on dealing with this. Because if we create an impression that we don't have this problem, when we come back here, you'll be asking us this reality. And for us to say it's a legacy or it's a historic issue, we are not trying to make a scapegoat, but we're trying to at least be honest and tell that this is where we are. We now have to start trying to build the capacity internally, in-source, and look for skills, which, by the way, it's not easily available, that will come and assist us. Okay, I'll ask the Solicitor General to start, will be followed by the Deputy Director General for Corporate Services, then the Chief Master, and then the Deputy Director General for Court Services, and the CFO will follow. Solicitor General.
Thank you very much, DG. Thanks, Chair, and members of the committee. I think the question that, in fact, I need to apply myself to is comes from Honorable Horn, measures being put in place for the reduction of litigation costs. I think at the outset, let me indicate that the Office of the Solicitor General, with the assistance of the heads of offices of state attorney and the approval of the minister, has developed about 7 instruments to date that in fact are mandated in terms of Section 3, subsection 4 of the State Attorneys Amendment Act. The one policy that in fact I need to also indicate, which was developed, is the contingent management policy. And all of the policies envisaged in the Act apply to the entirety of the state. as you would know, honorable members, 3 of the policies were approved by Cabinet on the 9th of November 2021, and that is coordination and management of all state litigation. And the second policy that was approved was the state legal representation policy, as well as alternative dispute resolution. Now, those go to answer the question that Honorable Horn has actually alluded to. With all of those policies and owing to the standardization of the operations of the state in relation to consumption of state legal services, those policies are very critical. Furthermore, we have in fact established or developed a litigation strategy, as well as the briefing and outsourcing of state legal work, as well as the other 3 policies that were approved. Now, we were supposed to present the 4 instruments yesterday, on the 4th of April. However, the Cabinet Secretariat advised that we needed to get at least the SAYA certificate in relation to briefing and outsourcing of state legal work, which was outstanding. We have since obtained the SAYA certificate, and we are scheduled to appear before Cabinet in the next sitting, but we will start with the JCPS. Now, if all of those policies were to be read in whole, they, in my view, provide adequate measures to reduce state litigation. And that is what I need to report on. In relation to the other issue, Chairperson, that you raised, which is the briefing patterns, we in fact measured on that aspect. I know that you have indicated that perhaps that might be an item that we might have to speak to outside of this setup, but I'm satisfied that the briefing patterns are in fact standardized as it is, and we are able to have a line of sight in relation to what in fact is supposed to be in that space. The other issue that has been raised, which probably might not necessarily form part of what has been reported, is the SIU investigations and consequent management in relation to offices of state attorney or the malfeasances that are reported in that space. I think previously the committee had indicated that some of these issues, given the sensitivities that they entail and the fact that some of the heads of offices are on this platform, I would perhaps request that that should be an item that is parked, because there are sensitivities around the investigations that the SIU is conducting. But we might actually benefit from what they will report on. And I think the NPA as well, to the extent that some of the matters have been referred to the NPA, might have something to say in relation to those issues. But you will also note, Chairperson, that there is a matter that has been finalized at the Special Tribunal Court, where the court has ordered that there was some fraud and malfeasances in Johannesburg. This is a case that has been reported this week. I think it was on Monday, where we were given the latitude to recover almost just state attorney that was in jail. We'll have to report on based on the questions that the honorable members have raised. Thank you.
Thank you. Have you filled all your heads of offices? The last time you reported was 11.
Chairperson, regrettably, no. I'm still short of 5 heads of offices that must actually be appointed in that space. So I'm actually operating with acting head of offices.
What is the problem? Why are you not in full capacity?
I'm made to believe, Chairperson, that corporate services will be assisting us to advertise those positions in this first quarter. This is something that also the minister has directed that it ought to be done. And so this is a dependency that, in fact, I need to get corporate services and HR to assist in filling those positions, because it's very critical. You cannot actually operate with actresses and actors in that space. It's very critical.
The DDG for corporate services will come back and answer the question, why did it take so long for those posts to be filled? Let's add the question to DDG corporate services. She will come back and respond to that.
Thank you.
Yes.
Good morning, Chairperson and the members and DG and the Deputy Minister and colleagues. Chairperson, let me first start by the last question relating to the state attorneys. We have embarked on the process of evaluating the positions that are left for the head of offices. About 4 of them that are busy, we are busy finalizing. And we will be embarking on a process of recruitment of those ones, those approved and discussed with the SG. Chairperson, let me take you through the...
Before you proceed, this has been a problem for some time. And the minister, I think year before last, is one of the issues that he said would need to be attended to. So if we have made evaluation with respect to other heads of state attorney's office, why would it take so long for these 5 others to be concluded?
Chairperson, previously the other officers like the Toyando, Tata, Kimberly were not at a chief director level. Mm-hmm. So what we are busy doing at the request of the SG is that all the head of offices should be at the same level, because previously they were not, and we understand very well that in terms of the State Attorneys Amendment Act, all of them are supposed to be head of offices. It does not explain as to whether they should be at a lower level or not. So that is why the evaluation is very important before we can finalize the recruitment. But yes, I understand, Chairperson, that it has taken time. It has been a to and fro of ideas and between us and the office of the SG. But we are, I think, and also the DG, but I think we will be able to finalize the matter.
No, this one does not need to go to cabinet because the chief director level, it rests with you at the level of the DG. When should we expect this post to be filled?
Chairperson, I will engage with the DG and the SG. Recruitment process would probably take not more than 90 days, but we will have to discuss with the SG and finalize the process.
DJ, can we say when you report for the BRRR, this process must have been concluded?
Certainly, Chair.
Thank you very much. Can you proceed, DDG Corporate Services?
Chair, I will just add on what the DG has already responded on regarding the security measures that we have put in place to boost our IT space. We have implemented a wide range of security measures within our information processing environment, and that will actually it was intended to prevent any unauthorized access or use of sensitive information, and also to ensure that the confidentiality, the integrity, and the personal information of our customers and also our employees remain protected. So these security measures were categorized into 2 groups. We have put in place managerial controls that include a set of approved, published, and implemented information security policies, standards, and procedures, as well as guidelines and we have made an awareness of the existing information security policies and cyber security risks within our information processing environment. And we also have put in place technical controls in addition to the native security features provided by our systems and platforms. So we have deployed a set of automated security tools and processes to improve our defense capabilities and safeguard our ICT infrastructure and systems. So these technical tools, Chairperson, will enable us to effectively restrict and control access to our ICT systems and our applications and other services, and also to manage our vulnerabilities and proactively monitor and protect and respond to any security threat or incident that may come into our environment. We have also deployed disaster recovery capabilities to ensure continued availability of our business critical information in case of any adverse event impacting our services. And also, Chairperson, I think this will be the last one. We have implemented a zero trust network tool. This is a tool that will help the department to provide a secure remote access to applications and services based on the defined access control policies. So we have implemented all these controls, Chairperson. However, and I take note of and support what the DG has said, that in terms of the ransomware attacks, we can never say we are fully protected from the external forces that may all the time want to penetrate our systems, but we have at least put in some of the security measures. Now, in terms of the Chairperson asked the DG if we know how much do we need to deal with these issues that are relating to our infrastructure. Chairperson, for the 2022-23 budget of the DPW, I had a meeting yesterday with the colleagues in the DPW, and it was confirmed that in their procurement plan for 2022-23, they have put aside about 852 million over the MTF EF period for all the 88 projects that we have registered with them. And these projects are at different, are at different project status, including appointments of consultants and so on. And that budget is planned to make sure that they refurbish and upgrade and repair the 88 projects that relates to our infrastructure. Now, Chairperson, in terms of
before you proceed, sorry, so to say, DDG. Sorry, my apologies.
She's fully appointed.
Yes, yes. My sincere apologies. DDG, my question is, we need to move from the strategic to the tactical planning. Globally, I mean, you must have that a global view that says the problems generally in our infrastructure. This is the national picture. And then you are able to say, this is how long you think it will take for us to fix these problems in infrastructure. And then yearly, this is the budget that I would have. Because if you move from each problem to the next problem, sitting here, we don't have a picture as to say at this rate, if budget is given to us at this rate, how long will it take for a person in Musina. Fortunately, we were with you in Musina. You saw how the dire state of that court. There is a court that I was told in Lusikisiki by Honorable Breitenbach, where sewer sometimes gets into the court building. Now, sitting in Lusikisiki and Musina, we must know that there is this global picture about the infrastructure project. From on your side, it will be from a budget point of view, informed by what needs to be done. And this is what it's going to cost us. Taking into account that there are courts, new courts, Palm Ridge, Bombela, Polokwane, that still needs massive infrastructure, but we do not have a national picture. Over to you.
Chair, yes, indeed, we're together in Musina. The issue, I don't know, Chairperson, if you would like me to respond in particular to those courts that we've just mentioned, or we can give a bigger picture in terms of a report, in terms of where we are around the issues, and just giving a progress in terms of what the DPW has done in terms of each and every court. But in terms of the Musina one, we were.
Sorry, Didichi. No, it was by the way, just to illustrate. But the issue is that, do you have a global understanding of what is the extent of the problem? If yes, you can elaborate. If no, maybe something that you need to work on. Or you can say that you need time to come and brief us, because we are going to invite you again to deal with the oversight report that will be dealing with the specific areas. But we need, as public representative, to say, as part of our approving budget as Parliament, this is the state of affairs in as far as our courts are concerned. This is the state of affairs in as far as our prison facilities are concerned. This is how much is going to be needed to say, now we've reached a stage where we would say people in magistrate courts, even high courts, they go to a court that is accessible to people with disabilities, courts that have got running water, courts that have got electricity, not judges in the Supreme Court of Appeal using their own internet connection, because there's no internet connection. Those things, do we have an appreciation at a global level to understand those things?
Thank you, Chairperson. Yes, we do have a global understanding and appreciation of what is the level and the status of our infrastructure across the country, and how much it will be needed for us to be able to deal with all the issues. I would appreciate, Chairperson, if you could give us that opportunity to present in detail what is in the plans and what is the state of all the infrastructure. I would appreciate if we can be given that opportunity.
We'll do that. We will do that.
Thank you.
You can proceed.
Thank you. Now, in terms of the question that related to the KZN floods, the DG has dealt with it in general, but in our meeting yesterday with the DPWI, we were informed that assessments were done already by the technical team of their and then their other professionals on the 35 courts that have been impacted by the KZN floods. And the damages caused by the floods include flooding of our buildings, the roof damages and the leaks and damaged ceilings, walls getting broken tiles and broken window panes, and many other minor issues. And 17 service providers have already been appointed under the emergency delegations by the DPWI, and they will soon be commencing with the repairs. 5 courts have been assessed and it requires CAPEX-related procurement following SCM processes. So they still are going to be following those SCM processes. Unfortunately, we were told that they have also received an exemption from the court ruling, the AfriForum court ruling. So they will be able to go through procurement processes for those 5 courts that need full SCM processes. The bigger facilities like in Duzuma and Verulam courts have been given the DPW head office engineers to do a detailed assessment and designs. So we are in constant and regular consultations and meetings with the DPWI from our region, even in the KZN region. Our regional head is in constant attendance of the meetings that are being held at that level. Chairperson, the issue of the lift, when we were together in Bulugwane High Court as well, the lifts were not working, they are not working, and you indicated that over and above all that we need to do, the issue of the lifts must be prioritized. We have been informed by the DPWI that Otis Company, which is the OEM for those lifts, have been deployed already to attend to the non-functioning of the lifts. They took side on the 28th of April, and they are expected to finish their work by the 20th of May. And so today, 6 lifts are running, and others will be running by Friday, the 13th of May, except for the 2 lifts that needs parts that have to be ordered abroad. So the expected delivery time that was committed to us yesterday by the Department of Public Works is 3 months. Chair, I think I have covered all the questions that were left for corporate services. Thank you.
The issues relating to vacancies.
Oh, the statement.
No, the general vacancies, the chair addressed that.
Okay. Chair, I think the DG has already covered that part in terms of us committing that we will work very hard to ensure that our vacancy rate remains at below 10%. Overall, in terms of the departmental vacancy rate, we are already at 8.12%. We are already below 10%. In the past year, we have already appointed about 812 new employees. And the DG has already indicated how many we have appointed in terms of the SMSs, but we are still committed to ensure that we fill the vacancies within a reasonable time. Thank you, Chair.
I'll ask DG delay to legislative development and legal affairs to come before the Chief Master.
Good morning, Chairperson and honorable members and colleagues. There were 2 questions for legislation, one related to the Sheriff's Bill and the other related to the 3 GBV bills. And I think I'd like to start with the 3 GBV bills. The work to implement the 3 pieces of legislation are at an advanced stage. We have set ourselves the date of end of June to have all the regulations and other notices in place. In particular, Chairperson, the Criminal Matters Amendment Act requires the Minister to determine categories of intermediaries and to set tariffs for them. The consultation in regard to that is finalized, and we are just awaiting comment until the 10th of May, so that's just around the corner. The rules board has already started drafting the tariffs as required by the Act as well. With regard to the sexual offences regulations and the NRSO in particular, the draft has been prepared and it has been submitted to, there has been public consultation, but the one outstanding step is that the Act also requires us to consult with particular ministers, and we are waiting those inputs, which is also due in a few days' time. On domestic violence, these are quite extensive regulations. A draft has been prepared and we will shortly publish for consultation. So we are at this stage in line to meet the target of 30 June. The last issue on the Sheriff's Bill, I received a report that we are waiting comments from the Sheriff's Board. The draft has been with them for some time, and for some reason we have not received it, and I've requested that we follow up to see what the issue about the delay is. Thank you, Chairperson. Thank you, DG.
Thank you very much, Chief Master.
Thanks, DG, and good day, Chairperson, Deputy Minister, honorable members of the committee. There were comments, questions, 3 of them. Both the comment of Honorable Swart and that of the Chairperson relate to generally the same concern. But I'm really encouraged by the approach and explanation in the comment that led to the question that Honorable Horn posed, to say that yes, you present the targets, but these targets seem not to address the issues. The issues are frustrating, irritating, and really causing a perception to continue around the services that the masters are rendering. What is it that you are doing that will at least ensure that as you address the issues, that will have an impact of improving the perception? Now, an example he gave speaks directly to what we have intervened with as something that would stop this situation where somebody drops the documentation or delivers or reports a mistake, and then there's a silence, and then the period within which to issue the necessary appointment letter goes by, and months and a year even goes.
Sorry, Chief Master. Because of time, we know what Honorable Horn said. Can you focus on your response to what he has said and other people have raised? Because we're mindful of time, we still have to deal with the Legal Aid Board.
Thank you. The actual intervention we put in place is a self-help self-service that we have started in the Masters Johannesburg some 6 months ago. We had started to roll it out to the Durban Masters. We deployed desktops that are new to the Masters Pretoria. The pack that was delivered to the Masters Cape Town 3 weeks ago, I was informed yesterday, it has started to work. How it answers that question is that the professionals in the attorneys and those in the fiduciary bodies would come with their pen, report, register the estate, the appointment gets done. Whilst they are there, they leave with the appointment letter. Therefore, the frustration of in between where somebody says, I submitted all completed documents, I have not received the appointment letter, is being eliminated by the project. All other offices, we have managed to and have received delivery of 30 desktops and have distributed them countrywide. We are just in this coming 2 weeks working with the IT person that would make them operational. Cape Town was trained 2 or 3 weeks ago, but at least they started by yesterday. I am informed appointments are happening in that line. In the general, the plan that we as a branch have, I had presented it to the Minexco 2 weeks ago. I had given it previously to the ministry and it was then shared in Minexco. What is the deliverable? In broad terms, Chair, we want to produce a master services where the efficiency is top priority, but also sensitivity to the nature of the customer we're dealing with. Ours is not a customer who is happy, who is somebody who is really either in one way or another damaged or lower in their perception or aggrieving people. So we want to do that, but we're doing it basically through 3 key things that we think should be helpful in our spaces. If our IT can be very, very up to the game, then we will try to utilize IT to improve on the efficiency levels. But also we want to train our managers to know how to manage the space. Generally, we don't do it like it's been done in the private sector, where before we put somebody in the position, after you have promoted him into management, training before. That's our focus now, so that we at least, whilst we are having systems that are good, managers as a good fit for purpose to ensure that we achieve our deliverables. So in the general, the bigger plan is to produce that as an output. Thank you.
Maybe, Chair, for your comfort and the comfort of the members of the committee, we have taken an approach to pull out masters as a priority, and we should be able to start showing milestones on 6 monthly basis. Because here as well, we're dealing with an issue of legacy. The system itself is old, but at the same time, there has not been a concerted deployment of a system to assist with many other things. Basic stuff like just pure management that we need to bring into that space to deal with the general queues that you see all over the country when you visit the master services. But also, you know, Chair, last year the minister had to authorize this SIU to get into that space to deal with the matters of corruption and unethical behavior, which is still a major challenge. But with this transformation part, all these issues of building managerial capacity, but the digitalization part as well is part of what is required. And in this respect, we are trying to work with our colleagues from SARS as well to see the solutions that they have, that is trying to build SARS to be what it is. It is an ambition, a desire. We will not necessarily be there overnight, but we have realized that the need that just the master services has to be a focus that we can at least on a 6 monthly basis say these are the basic milestones that we want to see. And there's no doubt that a bigger part of it will require the modernization as well as the human capital development part that the Chief Master was talking to. We'll continue. I'll ask my colleague, the head of the Integrated Justice System, to respond to the issue that we raised about IJS.
Well, thanks, DG, Honorable Chairperson of the Portfolio Committee, and honorable members of the Portfolio Committee. There were 2 questions that were raised. One was relating to the APP as it pertains to only additional for one department having to be connected to the IDS transversal hub. I think one needs to raise it here that all IDS member departments are already connected to the transversal hub, Home Affairs, SAPS, DOJ, DCS, Social Development, Legal Aid South Africa, OCJ, NPA, and SASA in particular, because they required to be connected so that they will be able to use the person verification services, which they've used successfully during COVID to combat fraud, to verify the beneficiaries of social grants and across they've made around 4.2 million verifications around that over the past financial year 2021-2022. When we say the additional department or one department to be added, it's on the basis of the request that we get either through SAPS or Home Affairs. And in this case, we have an instance where Ict or CIRA would request SAPS that they want to participate directly on the transversal rather than to rely heavily on SAPS. And I think on Tuesday, the minister did indicate that the program in its nature, its success and achievements are mainly accrued to member departments. And with the new governance framework, we're trying to bring everything and consolidate everything so that the impact is also seen directly from the IJS program itself. And the other thing that the chairperson has raised relating to the assessment report, you would recall that in the last financial year, in our APP, we had the implementation of the recommendation of the DPME assessment report. We have not automatically removed it, Chair. It is in our branch operational plan, and we are still responding to remaining findings or recommendations made by the DPME. Yeah, but I think the report is available. We will also furnish the portfolio committee with that DPME assessment report. Thanks.
The report is available, but we asked for it long time ago. We have not received it.
We will avail it this afternoon, Chair. Okay. We will request the acting Deputy Director General for Court Services, Mr. Malema, to respond to the other issues relating to the courts.
Good morning, Chairperson and honorable members, as well as the DG and the colleagues. I'll deal with a few questions that have been raised, and my colleague, Ict Infrastructure, will assist and add where I may have omitted. Chair, I just want to start off by saying that below the APP, we also have branch operational plans where much of the details that we couldn't put into the APP are actually also placed there. And the DG has committed that that is also going to be monitored very, very closely so that the entirety of all the plans of the department to improve services are dealt with. So even though you may see reductions in certain KPIs, it doesn't mean that actually disappeared. They are still part of the broader plans for the department. It's just that they're not appearing on the APP. So I'd like to start off by responding to the CRT and the SOS mentions. And I do want to say that we do understand the frustrations of the members of the public and the professions and the magistrates. We're working with data centers. We meet with them every week. We had another meeting with them yesterday to look at the progress that they have made. They've already set up. I think the difficulty that they had, Chairperson, was that when they started in February, as the DG said, they needed to set up, and setting up for the whole country takes quite some time because they need to get equipment, they need to recruit the technical people and deploy them across the country. And so that took some bit of time. And I think also because the contract was initially for a 2-month contract, but subsequently it was then extended to a 12-month contract. So I think initially on the teething problems immense, but right now they are actually they're on the third phase. They've visited all the calls where the calls have been logged. And they've dealt with those matters. They've done the assessments. Where they needed to do repairs, they carry kits where they're able to do repairs on site. The major challenge is that some of the equipment that they need to fix must actually be procured overseas, but they have already done that. So we're merely awaiting for them to actually receive. And in fact, some of them, they're getting them as we go along. But in addition to that, Chairperson, we've made an allocation of about 26 million additional for them to actually do, procurement of hardware for about 11 million, for CRT and hardware for sexual offences, because the sexual offences system are really of such a nature that they cannot be repaired. And this is based on the report that they gave us. They put about 5 million, and then the general maintenance and support, so that we do not get to this position where we don't have, a system in place to do the maintenance. So this is really the interim one for the, the short term, but there is also the long-term one, the one which is for a period of 3 years, the contract that will take into place. So I thought I should clarify the issue around that, but we've also looked at the numbers. And obviously, we want to have all the courts functional every day. That is the ideal that we want. But, as things stand, we've looked at our performance in terms of the CRT. Those that are functional, we're at about 75% capacity. So about 22.5% are the ones that are not functional. Those are the CRTs. If you look at the sexual offenses, we've looked at an assessment there as well. Again, the functional ones were at 69.4, let's say 70%, and 30% of them are not functional. And obviously, this is cold comfort for people that are coming to court. Those that are getting the 30% that is dysfunctional. But it's something that we're working closely with the CRT, with the data centrics and the judiciary, so that we can inform them. We considered several options. One of them being to procure ordinary recording equipment that is used in courtrooms and that kind of thing. Those things are available readily, but the main problem that we picked up is that we would have difficulties later when we have to get the court records. But also on matters of trial, we find that we are able to sequence and put together a trial that might be taking place in different days. So we were a little bit cautious to go and implement that solution, because it may create further problems down the line when the appeals and reviews and the records are required. And hence we didn't want to go that route, because it might solve an immediate problem, but it might create a very difficult long-term problem for us. When it comes to the second aspect of the NRSO, the reduction there in terms of capacity or in terms of the targets was really largely informed by the capacity that is currently available in the unit. The DG has since provided additional capacity, so there will be a process to actually procure more people to be in the NRSO. But we also consider, Chairperson, that there's a lot of cases that are coming in and that they need to deal with. There's a lot of volume. I mean, if you just consider the category of people that must actually apply and be vetted, it's a lot of people. Teachers, policemen, social workers, it's a whole lot of people. So we put this number because we also put it a 10-day turnaround time. So we give them a tighter turnaround time to perform, but we also needed to be cognizant of the capacity that we have. And lastly, on this aspect, Chairperson, we also looking at decentralizing certain functions that are actually cloning the system at national office, because all of these things are taking place at national office. So we're looking at creating capacity in the regions amongst the directors legal, so that when people want to apply and check, does my name appear in the register, does not have to come to national office. So that way we can then free the register to actually focus on the issuing of the clearance certificates, because that process takes some bit of time. So we thought we could separate that, and I'm sure that in the new financial year, once we've established and set up in the regions, we can then improve again on the numbers that we've set as targets for the NRSO at national level, because we have decentralized some of the functions to the regions. On the aspect of the backlogs, the DG has mentioned that earlier on that we've set up last year we had a framework. Now we are putting it into place. So it will be the National Backlog Optimization Committee that we're setting up. We're in consultation with the different stakeholders. We put a plan together. So we're just awaiting for the first meeting to take place. But we're also excited that we'll be taking part with the first meeting of the National Efficiency Enhancement Committee that is being convened by the Chief Justice. But the regions will also take part in the provincial enhancement committees that are chaired and convened by the different judges in the high courts, as well as the chief magistrates and the regional court president. So all of those together with the partners within the criminal justice system, we want each party to come in and we craft a plan that they will then be responsible for, and hopefully which might be in their EPP, so that from the side of the police, there's a commitment in terms of what they will do, from the side of legal aid, from the side of NPA, so that we then are able to deal with this matter, in a holistic manner. And insofar as the sexual offences chairperson, again, there on the reduction, it's really a function of the modification of the courts themselves, so that they can actually comply with the regulation. There's a regulation that have a number of checklists that we need to be looking into. So we're busy with that. We've done the audits, so that's why we've done a reduction, so that this reduction is actually informed by the physical modifications that are actually necessary. Chairperson, you'll appreciate that the older courts were actually not built with the requirement of Section 55A. In mind, there was no talk of sexual offences at the time. So we find that many of the courts are actually not amenable to the modification. So our numbers around what we are doing are really based on the objective reality of what actually pertains in the court. The same would apply to modification for making the courts to be disability centric. That many of the courts, you find there's no lift. There's 3 floors or 2 floors. The courts are on the upper floor. The court was not, there's not even a lift shaft, because if there was a lift shaft, then you bring in public works to put in a lift. But the court was never designed to have a lift. Some courts were actually not even designed to courts. So they simply modified, but we'll continue to see what changes we can bring in, because it's important that we respect and recognize the rights of people with disabilities, that we actually are able to make modifications so that we can reasonably accommodate them. The last aspect that I will address relates to sign language interpreting. And I must say, Chair, we do apologize for what has happened recently with what the member mentioned of a person that was brought in. That we try to work with the various NGOs that are in the disability sector, that as far as possible, the regions source sign language interpreters from those organizations, because at least those people are trained and they're credible. We're not just picking up anybody from the streets. But internally within the department, we have re-established the language services unit, and we brought in colleagues, senior interpreters from across the country that we have borrowed to come and re-establish language services. And amongst the units that will be foremost that we need to, people that should be there to assist us, would be somebody that will lead around sign language interpreting, creating capacity and awareness, and interfacing with other people, but also foreign language interpreting and local language interpreting, creating capacity. But eventually, the idea that the DG is looked at is that we want to professionalize the profession, so that people that are interpreters are qualified, they're competent, and they are accredited to a particular body. And so that would be the submissions that I would make. And Chair, the DG through you, Ict Infrastructure is unfortunately not well, but she is online. If she has anything to add on the NRS issues, perhaps she would be allowed to do so.
Advocate Kambule, on the NRS, or not only that, I think there was something to do with the number of courts being 27.
DJ, how many people are left to do the responses?
Only 3, Chair. Only 3.
Can they be brief?
They will. Advocate Kambule, not for more than 5 minutes, please.
Chair, I also want to do give a response at the end.
Yes, dear.
No, Chair, when you're asking how many is coming, I just said I wanted to include me as well, please. I'll come at the end.
No, I was asking people from the department, you are not part of them. You always have time that is dedicated to you.
Advocate, please come to unmute yourself and please, they're not more than 5 minutes, please.
Thank you, Gigi. I just want to, I think a lot of things have been covered. What I can say is that with the disability-centric courts, we started with such a huge number and achieved 78 courts that we made them compliant with the minimum standards for the disability strategy that we have. But now we do not want to repeat what we did, the error that we did with the sexual offences courts of establishing them and moving on without looking into the issues of monitoring and ensuring that there's full compliance with the strategy and also the minimum standards, because in each and every court that we established last year, upgraded rather last year, we also nominated the reasonable accommodation officer that will ensure that at every service point there are services that are offered that are responsive to the needs of the disabled court users. So that is one reason for us then to see, because this is a strategy that we are implementing for the very first time in the country. So we need to monitor and continue as well with the upgrading process. And I will also say that in terms of the MTSF, we are required to establish 54 courts, which we have actually now achieved the entire volume. But that is not stopping us from moving on. And the other thing is that we are also going to be reviewing the minimum standards and engaging with the disability community to see as to what is it that we can improve, where there is a need for improvement, since it's a new program that we are coming with. So I think that is what I would like to add. Then with the sexual offences courts, I think that is something that is similar to that, to say that there are infrastructural challenges with the MATSO courts, and also there are certain challenges that we have noted. So we just want, as we are starting, because right now the regulations have introduced a new model that is quite it requires more resources than the MATSO sexual offences courts model. So we need then to ensure that these 80 courts that we're going to be established are the model courts, are the courts that are fully compliant with the regulations. And then we move on then with the process of ensuring that then we have the national footprints of these courts. I think that is all that I would like to add. Thank you.
With respect to the 17 courts that you have done, can we get a list of all those courts?
All right, we will do so, Chairperson. And actually, there are 78. They are not 17. Thank you.
Chair.
78.
Chair, Honourable Wilman Yuhodruchen.
Honourable.
Apologies, Chair, for interrupting. My question regarding intermediaries has not been responded to at all.
Yes, they're still responding. I think let's check if they're not going to respond. We're still receiving responses. Let's wait a bit. Maybe they will respond. And if they have not, then we will ask them to.
Okay. Yeah, in fact, I'll just ask Advocate Kabule to respond to it, include that question on intermediaries.
Thank you, Dija. I will have a limitation because I joined the meeting quite late. So on the questions that I received from Mr. Malema, there's nothing on intermediaries.
Okay, Mr. Malema, ask the CFO to briefly deal with the. You can mute Advocate Campbell.
DG, why are you allowing Advocate Campbell to come to work being so sick?
It was her and the supervisor who made this arrangement. I didn't know but she's a model public servant that is willing to die with her boots on in service of our people.
So, Chair, may I say?
You must be a model employer. Honorable President Bakhtiji, you must be also a model employer that is very much caring. We can't celebrate people dying at work.
Yes, Chair. No, she's at home, so she took advantage that virtually she could still make some comments on some issues.
Thank you very much, Honorable Breitenbach.
Thank you, Mr. Chair. I'm terribly sorry for the interruption. I must agree with you. Ms. Kambula is obviously very ill. And there can be no reason why she should be forced to participate in this meeting. There must be somebody who can answer on her behalf. She can't be the only person who has this information. And secondly, Chair, the list of courts that you just asked for, could you put a timeline on getting that list? Otherwise, it's going to be like the other lists that we never get. Thank you.
Yes, next week, Tuesday. Yeah. It can't be next week, Tuesday, by end of business.
Chairperson, if I may proceed, and we do want to express our apology. I have been in discussions with Advocate Kamule online, and she did say she's not well, but she will join. So it's not like, I did personally even say I'm sorry to, to request info from her. She mentioned that she's booked off, but she'll be able to just deal with the issues while she's at home. So it's not like we were being insensitive. There's quite a lot of people that are not well. So she will then be requested, but she agreed on her own.
Mr. Malema, I think it's better that you must leave it there, because I don't think that we are doing any service by pursuing the issue. I think we have made the point. I think let's leave it there. Let's proceed with the responses.
Yes, Chairperson, I'll deal with the intermediate, but I didn't get quite the full question because I may have been outside. And I'll just talk broadly about it as I understand the issue. That the main problem that we're having with the intermediaries is that, especially in places like Gauteng, that's why we have fewer intermediaries. So the approach that we have taken is that because of the funding limitations, we will then use the DPSA regulations around the appointment of contract workers so that we can then bring in the ad hoc intermediaries. So this it's already regulated, the rate at which they must be paid hourly and per day. And so this will immediately free the regions to be able to source them. Because the main challenge has been that the ad hoc intermediaries that we use, which are like contract workers, called in as and when they are acquired, is that the rates at which they were paid were only rates, and many of them actually moved to DSD where the rates are much better. Now we've brought in the regulation that we had overlooked from DPSA that will then give them the rate of people that work, as casual workers, which are much better. I hope I've kind of dealt with the issue. My apologies about this, the actual question. Thank you.
I'm asking the CFO to answer those two questions on the payment of small business and as well as the 40% set aside for women.
Thanks, Chairperson. The members are correct to say that these are already undisputed invoices. But in line with the DPME framework, we needed to adjust the target to account for things beyond our controls. Normally, we try and make sure that we pay 100% on time, but there are dependencies that we use transversal systems to make these payments. So if a service provider changes banking details, for an example, the system will not allow the payment to go through. And we are seeing those more often. And we had to make that room for those kind of cases. From the department side, we try to remind service providers to say, please make sure that if there are any changes in your banking details, make changes also on the central database so that the system cannot block payment from going through. But otherwise, we are very much committed. Almost 99% of undisputed invoices in the previous financial year were paid. In relation to setting aside
sorry, before you proceed, if you are able to achieve 99%, but why do you reduce the target to be 98%?
We had taken 2% based on historical information. When we set the target, we had in the previous year achieved, in the year before the current, we had achieved 95%. So we had pushed it to at least 98%. Now in the year that is coming, because the 2022 financial year has improved, we are gradually moving towards system-free issues, which we can be able to achieve 100%. I can just commit Chairperson to say we are trying to be smart, to set targets that are achievable. We didn't want to put something that we know for sure there are those issues. When we report to Treasury on a monthly basis, we put all those reasons and we ask them to deal with it. But we still commit on our operational plan, we work towards 100%.
What will the 2% drop or change make in terms of your own operational efficiency?
It really doesn't change much. It's a number.
So why is it not 100% then?
We wanted to put a target that is in line with the framework of being achievable.
What is the science?
So
what is the science behind that 2% drop then? If it were to do anything?
It's best practice, the variance that is normally acceptable, it's 2%.
But
based on previous.
We are talking of a cabinet decision. Cabinet has been very concerned for a very long time about this. This should be a serious priority for departments, especially a department that has got a budget of above 20 billion. Small businesses, most of them are collapsing because government is not paying on time. It's not a small issue. They are collapsing because government is not paying on time.
I think, Chair, the point that she's making is that the performance agreement and the operational plans maintain that. But if you look at the size, as you are talking about, just the size of the department and the procurement that is done across even the courts, is that the reason why the reflection of the past 3 years we can never clock 100% is because just this very old system that we're talking about, which is a dependency, if it doesn't work, then it gets paid. When we did an analysis of saying that 0.1%, where would it have come from? It will have come from payments that were made within 35 days. And why were they made within 35 days instead of 30 days? It's because either the system was not working. Forget the ransomware attack issue. But at the same time, with what we recently experienced now, we are still in the pandemic and the 5th wave is coming.
majority of people not coming to work because you will only be allowed to have 50% of people coming to work, then the people who are supposed to process the payment. But it's a matter of commitment at the strategic level. That's why the 2% variance that she's talking about. And also linked to that, Chair, there are targets that you will see. A target is sitting, for example, at 85%, but the return at the end of the year still shows you 88 or 90%. Because target doesn't mean that if you have gotten this, it's not sky, it's not the limit. The target doesn't become the limit that says because you have achieved it, then you stop. So that's why that 2% variance of being realistic with what has been experienced over the past 3 years when it comes to the payment, that at some points, there were those that were paid even within the 31 or 32 days. Just 1 day outside would have made it. And the reason why it was not because of people's ineptitude, but it's because of other external reliances like your system that currently is not a dependable or reliable system that works all the time. When you have load shedding, when the power is back, to reboot the system, it's not automatically within the 1 hour. It takes time for the system now to come back and start running. Just that alone can affect what we have processed within 30 days. However, Chair, I think with it and the other ones have been explained, and we have them in the operational plans. And in 6 months, when we do the accounting, we should be able to account for them, because that's why I've never said we're removing from the radar of the plans. The plans is the APP, is the operational plans, and it's the performance agreements that colleagues sign. I'll ask the head of strategy to briefly comment without taking more time, Chair.
Thanks, CJ. I think I just wanted to respond on the issue of the service delivery improvement plan. Honorable Chairperson, previously the service delivery improvement plan legislative framework required that the service delivery improvement plans be reviewed every 3 years. And for now, it has been changed, so they are actually reviewed after every 5 years. So based on the operational plan, based on the operational performance and service delivery complaints, services are identified for improvement. So our current service delivery improvement plan captures services which the department is experiencing challenges on. So the 2011 service delivery improvement plan did not capture services such as expansions, guarantee funds, etc. So we are basically in line with what the new framework requires. Thanks.
The Chair, there was one part that was raised by Honorable Judge. I thought maybe for the records we may also have to comment on it. The difference between our approach of the turnaround plan and what he would have preferred as a rescue plan, we don't agree really that it is cosmetic. Our difference, our appreciation of the difference there was that we didn't believe that we were out of our depth in terms of turning around the department, and that would have required some form of administration, either by Public Service Commission. So that's why we developed a rescue plan that deals with 8 strategic key pillars. And then that's why we're saying we are convinced that we were turning the corner, even as we come back to update on other matters. We're not saying we don't have the challenges. So it's not cosmetic. And we have now subjected that very same turnaround plan to the scrutiny by Public Service Commission, as well as the Department of Planning, Monitoring and Evaluation. They have agreed to come into the department to look into the plan as well as look into our processes. And Chair, earlier relating to the other matter, which we sincerely apologize for having had a colleague, is part of our turnaround plan that on human capital development, we have to be caring about our employees, not only professional, but even in terms of their health. And that's what we are seeking to work on. I guess all of us, in our quest to make sure that we provide whatever the answer that is available, sometimes we sleep and not get not take into account that
there may be other, conditions that will not be acceptable. With regard to COVID, and I think we must make this point as well, we will never use COVID as an excuse. The reality is that in spite of all the challenges that the department has been going through, there are officials of goodwill, hardworking, professional, and committed. Our courts is what makes us remain to say we can never use COVID as an excuse. Even at the hardest lockdown of level 5, there are officials on the ground in the coalface who continue to go to work and make sure that access to justice happened. Without the luxuries of good offices, even in those dilapidated buildings, there was never a report of courts that were closed across the country due to COVID. So we just mention it where the reality is that there was an impact, but not to say it was an excuse. For those colleagues who continue to work even under those difficult circumstances, continue to get a call face and make sure that services were received. I thought it was very important that we make that point that we'll never do that. And the different phases of lockdown have actually proved that point, that courts in the main, albeit at a reduced level, continue to function, and they were made by the officials from the department who supported the administration of justice. Thank you, Chair.
Thank you, DG. There are questions that have not been answered. One of them is, why is the Office of the Legal Services Ombuds not operational? That has not been answered. The other one is the question relating to the President's Fund for Community Rehabilitation Projects under the TRC. It has not been answered. Yes, those two.
Thank you very much. Maybe let me start with the last one, or maybe with the first one, the Office of Legal Ombuds. The office, I had a discussion with Judge Desai, who has been appointed as the legal ombuds 3 days ago. He's waiting for a date from the department and the ministry for the launch of that office. But for the past 8 to 12 months, if I'm not mistaken, there's been work that has been done. We have seconded officials from the department to assist. There's an issue of a budget. The only budget that we will get from Treasury that we will include in the departmental's budget, it's not more than 5 million. And it is that budget that we have allowed the judge to make an advertisement for legal personnel that will assist him to process complaints. So the office, there is a skeletal structure that is already in place. That's why he's comfortable himself that we can start moving into a launch. So if a date is given, the idea is that this month there will be a launch, and with the details, we needed to have a website that can work with emails that can be sent. But so far, we have deployed officials of the department. I think it was between 6 and 8 officials that are currently assisting him. I'll ask DG Khalid today to add on that if there's something that I've left out. The TRC rehabilitation program. Look, you would have seen, I mean, the newspaper reports of people who staged the sitting at the Constitution Hill, demanding that they require payments and all of that. The report that we got, as you will know, after the TRC did its work and concluded the report, there was a list that was considered by cabinet, recommended by the TRC, and there was a closed list, and there was an issue of cash payments that were supposed to be made. From the advice that we got is that the organized, community organizations that have been set up, there are those that could not accept the recommended once-off amount of 30,000 and demanded instead 120,000. And that's the report. That's what the report shows. But the other issue general, which was the recommendation at the time, the understanding was that those recommendations were going to be folded into departments that do work like human settlement, that the Department of Justice and Constitutional Development was not going to go into communities and start developing RDP houses or doing developmental work in those communities. The understanding was that the specific department working with the municipalities will target those specific communities to bring development. Because whatever the amount that is there, either because of interest, there's this other segment, Chair, you will know that we are administering the payment of school fees for the children and grandchildren and great-grandchildren of the victims of the TRC and assisting them. But the understanding as well, there was that the Department of Education, through whatever the program is, including NSFAS, was going to ultimately absorb and take the responsibility. So the responsibility of the recommendations of the TRC were going to be devolved into the different state departments who have those specific responsibilities, than to turn the department into a machinery that specifically now deals with education-related matters. But now we continue to do that. So that amount, if you were to project for children who are currently in primary school, the 1.8 billion would not necessarily say it's a lot of money that will be able to take responsibility until university. So when it comes to community rehabilitation, the discussion is going on with those relevant departments to identify those communities and make sure that general government from local government take responsibility for the work that has to be done. It is unfortunate that it has been many years since the TRC made these recommendations, but when the minister and the deputy minister got a briefing on this, the proposal we made was that we get a full report so that it can be taken to cabinet so that the matter is closed than to leave it the way currently is. So the Department of Planning, Monitoring and Evaluation has been asked to come in and starting some work in order just to do the whole review of the recommendations and make recommendations, and make conclusions to the department for possible presentation to cabinet. Khalid.
Thank you very much.
Thank you.
I'm asking DG delay to add if there's something on legal almost that I've left out.
Oh, okay.
Thank you, Chairperson. I'll be brief. There are no legal impediments to the office operating fully because it has been proclaimed in terms of the law. However, as correctly stated by the DG, there are the financial constraints, and also we've taken an incremental approach, and I recall that there's one issue outstanding, which is for the list of lay persons to sit on the committees of the Legal Services Ombudsman that's still needed to be done. Thank you, Chairperson.
Thank you very much. Members, are there any follow-ups on Honorable Janji?
No, Chair.
Yes, Honorable Janji.
I had asked that simple question, and the DG has responded, Chair, in a very confident way to indicate that as far as they are concerned, they have presented to us a credible strat plan and APPs. I think, Chair, my follow-up is perhaps at the end when we conclude, we might have to agree to a process where some of these things will have to come back to the committee, because having asked that question, as you indicated, and many other questions of members of the committee and their responses to those questions, especially your questions that you pose, there is no way that you can continue to respond and say the plan is credible. I was here throughout the meeting. So I accept the view that there are just lots of questions about this APP that has been put here. I mean, you would have thrown in so many questions about why this target either was reduced or removed completely, and you're not getting reasonable answers to those. I understand why they would defend themselves, but from the point of view of an oversight, it's very clear that both on quarterly basis when we oversight and when we come back to the annual report, what has been presented to us leaves so much to be desired. So I think they have answered my question themselves, Chair. That's that the verbal is how the DG is verbalizing it is which I accept is an attempt to say they would not have come here and prepared a plan that is not credible. But I'm convinced that they need to do some more further homework on the plan they have presented to us. I'm just not convinced that with so many gaps and loopholes, you have got a deputy minister that says, here, Chair, no, I did not agree to that target. Huh? And you want to continue saying that the plan is credible. So I ask that we leave that, but I don't think that the response to that is the helpful one in relation to that issue. And with that, it ties in on the many other issues that I would have raised. I wouldn't want to go into that. So I have my answer, Chair, and I think it leaves me with a lot of homework in terms of how we'll need to go forward playing an oversight in the department. Thank you.
Thank you very much, Honorable Janji. Any other member who want to make a follow-up or make an observations before Deputy Minister comes? I think
perhaps just to add to what the Honourable Dankie has said, and I agree with him fully. It's just another indication of the deep-seated, deep-running problems in this department, and they're just not getting any better. So, yeah, this has been a disappointing interaction all round.
Thank you, Honorable Brittenbach. Honorable DM.
Chair, I'm not sure if I'm allowed. I just wanted to make a request.
Okay, please do that before the DM.
Yes, you will recall, Chair, Honorable Janji, when I was raising that question, and I answered in a monosyllabic manner, and I did raise that I needed to know the questions that you said, and they were going to come as a follow-up. If this meeting is of public record, it's only fair that we will not leave here with the understanding that the general feeling is that we didn't present a credible APP. Before we bring the APP here, it gets tested by the Department of Planning, Monitoring and Evaluation. And whatever the test that they use, they make comments to us and we respond back, and they reach a level where they say, we are comfortable that with this plan, you are giving an account to the South African public on how you will spend the budget that is allocated to the department. That's one. Two, if because we are planning within the MTSF, an APP, we are eating at the MTSF elephant 1 year at a time. The loopholes and the gaps that are said cannot be said to be a major divergence from the APP that was presented last year, unless if the APP that was presented last year also was found not to be credible. Now, there are some targets that once they are achieved, they don't come back the following year in the broader scheme. And I gave an example. Last year on state, on transformation of state legal services, there were policies that are emanating from the State Attorney's Amendment Act of 2014. And once those policies, all three of them were part of the targets, were achieved, they don't come back this year. So they end, some of them are time bound. But ultimately, when you review the MTSF after 5 years,
you will be looking at a bigger picture. So is the contribution that we're saying, if we have a target that was achieved over 5 years per year, this is what we can take. So I'm just saying that it will not be fair if the general sentiment is that we didn't present a credible APP, because our conviction is that if you look at the APP of last year and this year, you wouldn't tell me that the variance is more than 15%. And these are scientific approaches that I used. Thank you, Chair.
Thank you, Honorable Janji. Your hand is up.
But just to indicate, Chair, to say to the DG, we have no problem calling the DPME to come and themselves tell us how they reached a conclusion that what passed through them is credible. That could be part of our way forward. We have no problem to do that. It's in our powers to do that. The point being made here, and I stand by it, I'm not convinced, Chair, based on what was presented to us. It's one thing for the DG to defend for his life their plan that they work so hard on. The fact that you did that doesn't mean that we must just agree. Because you were asked a simple question about the credibility of, because that is the test we use in the discussion of annual performance plans as compared to your annual report. Having listened not only to the questions I posed, but the questions I posed, as the chair indicated, the answers to that, it's less about what comes from you, but more about the many other questions that members ask here. And therefore, the collective composite nature of those makes me to make this conclusion that I'm making. Your response is unconvincing. And I think if you don't want to leave this meeting because I carry a strong view that you have presented a plan that is not credible, so be it. Thank you, Chair.
Thank you, Honorable Janji. The Deputy Minister. I see.
Chair, thanks very much. And I think it's clear from the interaction that the department has a number of challenges. So there's a lot of work that needs to be done to overcome those. Just a few points in response. You, Chair, had raised the issue of my position on changing the targets, and there's some that's been said about the payment of invoices within 30 days. And I'll just read from the response I gave on that memorandum. I strongly oppose changing this indicator. Government's target is 100%. How can the DOJ be less? This is payment of undisputed and valid invoices only. More work should be put in to ensure this target is met. Suppliers should not have to suffer. So look, I'm in full agreement with you. And then there were other comments on changes as well, but I think that's more of an internal issue. I really just wanted to respond on three issues. The one was, I think you'd mentioned Lusiki Court of the Honorable Breitenbach saying there were problems of sewerage. I visited the court about a month ago. They didn't tell me about that, but the problem of Lusiki is the same as Musina. A contract was given to renovate the court. There's then a dispute between Public Works and the contractor leaves. At least with Lusiki, I can't remember offhand, but they do have dates. It's been put out to tender again, and they do have dates when people will come. But a lot of the problems, Mamelodi, Port Shepstone is about, Port Shepstone at least, contractors going into business rescue. And then the whole thing grinds for a halt for a number of years. So those are some of the problems which I think are even difficult for Public Works to control. Then on the issue of the Master's Office, I am very concerned about service delivery in the Master's Office. I think it would be good if the portfolio committee can include visits to the master's office as part of its insight. You did visit, or a group of the portfolio committee visited the Cape Town master shortly after I'd been there. I visited both Cape Town and Pretoria, did in the case of Cape Town a 6-page report, in the case of Pretoria an 8-page report, but the response from the department wasn't adequate, and I'm particularly worried in Cape Town where it's still stories of documents that have been handed in not being found until the issue is raised. And then more recently on one of the earlier matters that I'd raised, which was of a letter of executorship not being issued for a long time because according to the master, the right documents weren't submitted when in fact, and they had to backtrack and agree that they had been. They then managed to lose the entire file, which I find astounding. But anyway, so I do think you should give attention to the master's office in particular. I then wanted to just deal with the issue of the backlogs, the court backlogs, which are obviously of great concern. It's obviously difficult not having backlogs when you don't have functioning court reporting technology or CRT machines. I'm concerned that it is taking too long to fix those machines. I got a call from the regional court president of the Eastern Cape yesterday, complaining about the regional courts in the former Transkei. In Mthatha, there's no regional court with a CRT machine apart from the commercial crimes court. An attorney from Butterworth contacted me this morning. Of the 8 courts in Butterworth, only 2 CRT machines are working. So whilst this carries on and whilst there's the problems with the sexual offences equipment, it's difficult to deal with the backlogs. But we did establish what was called a court optimization committee year before last, or during the COVID period, or when things were sort of starting to come back to normal. That was meant to be, it was chaired by myself, it was meant to be the key role players discussing, identifying blockages so that they could be resolved on a national level. So we had representatives of the regional court presidents, so I think most of them, almost I think all 9 attended. We had representatives of the Chief Magistrates Forum. We had officials from the Department of Justice, senior officials, generals from the SAPS, legal aid, NPA, etc. And that, as I said, was trying to identify what are the blockages nationally and what can be done about them on an incident by incident basis. Unfortunately, the regional court presidents then decided that they didn't want to participate anymore. The chief magistrates were fine. They felt that it was impinging on their independence, that they were being told what to do, which is something I dispute, and I don't think they've been able to adequately respond to that. However, it's been reported to the chair of the Magistrates Commission, but I think what I'm raising is there is a general problem relating to accountability of the judiciary for judicial governance, where they see it as their domain entirely and not for the minister, not for parliament. I mean, just to the Honourable Horn, he'd asked a question at the end of April to the Minister of Justice on which dates during the last 24 months did the National Efficiency Enhancement Committees and each of the Provincial Efficiency Enhancement Committees meet. Response from the OCJ, it's still not been formally tabled, but just to give you an indication, the National Committee and the Provincial Committees are judicial governance stakeholder forums, which are chaired by the Chief Justice and the Judges President of the divisions of the High Court, respectively. The request for information is contained in the question by the Honourable Member, has been referred to the Chief Justice for consideration. So you would see from that, I would have thought a valid factual question around how often do the Efficiency Enhancement Committees meet. The judiciary don't want that to be coming through the minister. I'm not sure then how those questions are answered, because it's also, I think, one has to be very careful about the judiciary accounting to Parliament. They're not accountable to Parliament or to anyone, in fact, for their judgments and issues. Yeah, those are some of the problems that we're facing. But thank you, Chair.
Thank you very much,
Sorry, Chair. Just before you,
Honorable Janji. Honorable Janji.
I just wanted to say to Deputy Minister that I'm thankful for that point, because those NECs, National Efficiency Committees, and the provincial ones, those are the matters that would take up with the JSC annual report processes. We are going to get answers to those, and nobody's going to say we can't, because the JSC, in terms of Section 6 of the Judicial Services Act, is supposed to account to us, and we're going to do our homework in that regard. Thank you, Chair.
Thank you very much, Honorable Janji. Now, I think we have come to the end of the meeting, but what I would like to raise is the following. When the minister appeared before the committee, when we were dealing with the issue of the recording devices that were not working, the minister was asked a question: how many times does he meet with the executive? And he said once a quarter. That was the response of the minister. From what we have heard today, people must bear in mind that is not only what we are hearing or what we have read from your reports, but is also the oversight visits that we do as members of the portfolio committee, as public representatives in our own right and in various constituencies that we are interacting with our people. As a portfolio committee, to date, we have been to 7 provinces. We are left with Northwest and Northern Cape. What we have seen in the provinces that we have visited, quite clearly, it cannot be addressed by such an APP. Even if it's on we know the APP is annually, but if you look at the problems there, because firstly, we must have an appreciation of what is the bigger picture. And each year, in fact, how long will it take for us to address what is the problem? And each year, how does each year contribute meaningfully to what is the solution to the bigger problem? I am not convinced, DG, that this APP does justice to that at all. And we are appreciative of the fact that Public Works as a department contributes a great deal to your problems. We have interacted with them over a period, and it's a very frustrating engagement. We are quite aware that there are other contributory factors that are contributing to what is a challenge to even to yourselves. But it is also worrisome that with all those challenges, they have never really been robustly brought to the committee. For instance, we wouldn't be aware of the fact that if you go to Toyando, somebody came and took a generator. Neither is the Department of Justice or the Public Works knows who took the generator. But the generator is gone. But somebody from government took the generator. We wouldn't have known that if you go to the Supreme Court of Appeal, we've got a big generator that only lights the passages. And the impact of that is huge legal costs because of postponement to the litigants. And those litigants is the people we are representing. We want, when we see a plan, we can have hope that the people we are representing are really going to see justice. We were with DDG Corporate Services in Musina. None of us can stay for more than a minute in the holding cells of Musina. None of us can stay in those holding cells for a minute in Musina. Yet, we expect our people to be in those holding cells, sometimes for the whole day. And they have plans that are more bureaucratic. They have been validated by Department of Monitoring and Evaluation. But what is the concrete situation on the ground? How does these plans talk to what has happened in Bombela and in Limpopo High Court, where in Limpopo High Court they have to use plastics to try and fend off a smell of a sewer in a new building? Because to those people, to ordinary litigants who go to those courts, you can't tell them about public works or justice or DPME. Government is one. Government is one. So what I think we would also suggest, we went to Umtata. There's a group that is led by Honorable Janji that went to Umtata. One of the issues that they were able to pick up is that the office of the master is in a very bad situation. And it's normal for people to sleep over just to be served. And it's a rented something something, Honorable Janji will correct me if I'm wrong, in a church or something like that. And we're paying hundreds of thousands of rents.
Yeah, it is rented in my church, the Catholic Church.
Catholic Church.
Yes.
But Honorable Janji, in Umtata, you have buildings next to WUSU, the former University of Transkei, where the former ministers and the president of the then Republic of Transkei stay. And there are people who have taken those houses and who are staying in those houses illegally. Now, has a conversation about some of the provincial infrastructure that the provincial public works has taken place? Because you are the ones who are on a pressure cooker. You are the ones who should be seeing these people who travel for hours, who have to sleep overnight, still and not be served. There is no space. There is no human capital that is enough. Generally, things are not the way they're supposed to be. Then if you come to those people, you talk some IT programs that we are going to bring. Whilst you are failing, whilst you are renting, we are using hundreds of thousands of rents to rent in Honorable Janji's church. You do not, and there is property, government property, not far from that church. The same problem we encountered in Thohoyandou. There are houses that belong to the former vendor, and we're told that no, all buildings there were taken over by foreigners. And if you go to the office of the master in the High Court in Thohoyandou, I don't think they've got more than 7 offices. They are cramped there. Most of the magistrate courts and this master's office, if a person can drop a matches, everything is gone. At some point, Honorable Janchi was always consistent in asking an issue of a risk register. And our understanding, because it is becoming much more clearer, that the executive or the strategic leadership of an organization must concern itself with risks, how to mitigate those risks, and if they eventually materialize, how to recover quickly from those risks, from those mishaps. Now, you have a potential risk of documents that involves lives of people. In some small, filthy room, in most of these master's offices and the magistrate's courts. And the risk is that those things can bend down, as we have seen in Venda, that there was a fire in two of the judges' chambers. Now, we can't be happy that we do not have a serious response to the problems that we have encountered. DG, I would suggest that you have an engagement with the DG of DPE. They have trained, ESCOM, Transnet, and Denel have trained thousands of highly qualified artisans, plumbers, electricians, fitters, and turners, quite a number of them. Because some of the problems we have picked up in some of the magistrate courts, they just need artisans. Because what the Department of Public Works does is that for everything, they will issue a tender and invite private sector to come and do the fixing. But we have to now recognize the fact that the state internally does have some of this capacity. And take into account that we are in a serious financial crunch. Now, to continue procuring everything outside, in fact, procuring everything whilst you can use your internal resources, it's not the best approach of managing meager resources in front of you. So I know that there are thousands of artisans, and to a certain extent, they have high concentration of engineers that are more willing. I know with Transnet, are more willing sometimes to assist. We have visited Limpopo High Court, Palm Ridge Magistrate Court, and Mbombela. But in particular, Limpopo High Court and Palm Ridge, one of the concerns that we have is that at any point, something tragic can happen, especially in Palm Ridge. Do we have to wait for that tragedy to happen? Where a building is cracked, you can see it's difficult. You can summon, myself and Honorable Horn were very concerned after our visit.
I a little portion and then later evaluates.
Mbokani, disturbing our meeting. We were very, very concerned that anything can happen there. And the people, the magistrates who are there are having that concern. They are having that concern. If you go to Limpopo High Court, I don't think that if you can have an independent engineer would say that court is fit for purpose. How is our budgeting process, our planning process responding to those risks? Because they are not really reflected here. So I do think that what you have raised, Honorable Janji, that there needs to be a further engagement beyond this process of budgets. It's very important because, Honorable Deputy Minister, this is your second last budget before your end of term. And next year, it will be the last budget before end of term. Can we, including ourselves, can we confidently say that we are leaving the department and the people of South Africa being better served than when we arrived? Can we answer that question confidently and honestly and say, we are leaving the department, we are leaving the people of South Africa better served than when we arrived? So, DG, these interactions, they are supposed to be robust because all of us, you included, and everyone, the staff and everyone, all of us, I think we are patriots. We want to do good for our country. We have spent the better time in Limpopo with the DDG for corporate services, very committed somebody. We have spent the time with Advocate Mobo, very committed somebody. We know that you are committed. We know that you are committed. But our commitment must be felt by our people. Our commitment must not look good on paper. Our commitment must look good and feel good by our people who are using our services. So dear, please, what we are asking from you, that the message must go to the minister, that a more urgent attention, 1 quarter for this department is not enough. We need the executive authority, the DM, and the minister to have much more regular interactions with the top management and top leadership of the department to ensure that there is proper monitoring. And we have to change things. If the justice system collapses, the justice system is the glue that holds the country together. We can't allow it to collapse. Thank you very much, members. It's 1 o'clock. Can we have a 10 minutes break and then we start with Legal Aid South Africa?
Sorry, Chair.
Yes, Mr. Mtonjen.
I have since checked with Legal Aid, Chair. I've asked them to be, but they say they can only, they are caught up in other commitments, Chair. They are only available from 2 as planned, Chair.
2 as planned.
Yes, so I think,
fine.
Yes.
It will allow members to eat.
Yes.
And come back.
We'll use the same link, Chair. Thanks.
Thank you very much. The meeting is adjourned for now.
Thank you.
Thank you.
Thank you very much, Chair, and the members of the committee for the robust engagement.
Thank you, teacher.
Perfect.
Perfect. Okay. No, that's
Yes.
fine.
Yes.
Thank you very much. I think my colleagues will be joining now.
Okay. You can remove it meanwhile, man, so that when you will project it when you're called upon. We just wanted to see if the system is working.
It's working. Okay. All right. No, that's fine. Thank you very much.
Oh, okay. Thanks a lot, man. We'll start at 2.
Thank you, Sia.